Which is the item number?
No, ಬಂದಿಲ್ಲ.
ಅಲ್ಲ item number ಇರ್ಲಿ down the line ಅಥವಾ
My lordship.
Yes.
Kindly. Serial number 49.
49.
9. It may be taken up immediately after vacation.
All those matters that don't reach will be adjourned and we commencing from and prepare the code. All those that don't reach today, because there's some part heard which we will take, you can at 4:30 you can come and ask the court officer. If there are dates available, he will give. Contempt dates will be given. Other matters from the week commencing from, we will pass.
Please.
It's serial number 5.
Just one,
Serial number 53.
just wait.
Admission matters.
My lordship, in page number 14, pair number 4.
Page number.
Page number 14, pair number 4. The total compensation ordered by the tribunal is 27 so and so, the interest 6% per annum. However, the claimant is not entitled any interest for the future prospects and the interest of delay period of 307. It is our appeal delay ಇದೆ ಸ್ವಾಮಿ, ನನ್ನ appeal delay ಇಲ್ಲ, ನನ್ನ appeal dismiss ಆಗಿದೆ, ಅವ್ರ appeal delay ಇದೆ. 307 days delay ಅವ್ರ appeal ಇದೆ ಸ್ವಾಮಿ. ಇನ್ಸೂರೆನ್ಸ್ appeal delay ಇದೆ ಸ್ವಾಮಿ.
ಹೌದಾ?
ಹೌದು.
ನೋಡಿ. ಯಾವ್ದು? Yeah, who submitted that?
My lordship,
Somebody must have submitted like that. Insurance appeal ಅಲ್ಲ?
ನನ್ನ appeal dismiss ಆಗಿದೆ ಸ್ವಾಮಿ.
Appeal number ಎಷ್ಟು?
ನನ್ನ appeal number 200202099 of 23.
Delay ಇದೆಯಾ? ಯಾರು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು? ಅದು ಬರ್ಕೊಂಡ್ಬಿಡಿ. Is submitted by the counsel for the appellants in MFA number 202099 of 23. That the appeal so filed by the claimants is well in time. But however, while passing the final order at paragraph 4, it is mentioned that the claimants are not entitled for interest on delayed period. But there is the order sheet today, there is the order sheet. In this case, 2 appeals are disposed of by judgment dated 10th September 2024, wherein the insurance company has filed an appeal in MFA number 202302 of 23 with a delay of 27 days. Due to inadvertence and oversight, the said delay is mentioned in paragraph 4 of the final order. As the claimant's appeal is well in time, therefore, the claimants are entitled for interest on the said award amount from the date of petition till its realization. Therefore, the wordings so used, so the sentence so used in paragraph 4, commencing from, comma, and interest for the delayed period of 27 days, comma, in filing the appeal, comma, comma, be deleted and corrected certified copy be issued to the claimants for further needful in the matter. If the parties have obtained the certified copies, they shall present the same before the copying branch to get the said certified copy corrected.
4 and 5, para number 4 and 5 madam. 4 and final ಆಗಿದೆ ಹಿಂಗೆ. Because post-person delay period.
It's also similar words commencing from excluding interest on the future. Excluding interest on the future prospects and for the period of 307 days be deleted. ಅದನ್ನೆಲ್ಲ ಸೇರಿಸಿದೆ. ಯಾರ್ದು ಕ್ಲೇಮೆಂಟ್ಸ್ ಅಪೀಲ್ ಅದು ಅಲ್ಲ, ಕ್ಲೇಮೆಂಟ್ಸ್ ಅಪೀಲ್ ಉಂಟೆ ಡಿಲೇ ಇಲ್ಲ ಅಂತಲ್ಲ ಅಂದ್ರೆ ನಾವು ಅಂತ ಎಸ್.
Lord. Challenge, Lord, the order of the tribunal, Lord. Annexure B, Lord. 102, Lord. 102. Lord, my name, my Lord, I'm respond number 4, my Lord, 103. My Lord, the respond number 4 herein, my Lord, the applicant thereon, my Lord, had challenged, my Lord, my Lord, transfer, my Lord, to, my Lord, government polytechnic, my Lord, Kalaburagi.
From where to where?
My Lord, I am, my Lord, working.
Where is the order?
Please. The order, my Lord, is at page Lord, Annexure G, page 10. 134, 134.
From where to where?
From, my Lord, Afzalpur, my Lord, to Kalaburagi.
Afzalpur to Kalaburagi.
Yes, my Lord. Serial number, my Lord, 245.
Page number?
My Lord, page number page 152. Page, my Lord, the internal page, my Lord, 17 and 18.
Nim page number go, num page number.
152, my Lord. Page,
ಅದಕ್ಕೆ self scrutiny ಅಂತ ಹೇಳಿ.
please.
ಅದಕ್ಕೆ self scrutiny ಅಂತ.
My Lord,
Self scrutiny
no.
ಅದಕ್ಕೆ ಅಂತ.
My Lord, there are large page numbers.
75.
At page 75, Nodi. Okay, just go into the internal page 18 of that Anubandha Vandu.
Yes,
Page, okay, 245
245.
from
My Lord, this is the name of the, my Lord, the private respondent, my Lord, at
Prabhudev.
Prabhudeva.
So
Lord,
now
Lord.
you have been transferred to his place, huh?
My Lord, I have been transferred, my Lord, here what had happened, my Lord. My Lord, mine, my Lord, is a spouse case. My Lord, I had uploaded, my Lord, under spouse case, my Lord, the prioritization. And my Lord, initially my name was, my Lord, placed in additional list. My Lord, one of the, my Lord, spouse person, my Lord, she was found to be ineligible, my Lord, while counseling for that, my Lord, the under spouse category. My Lord, since I stood first, my Lord, in the, my Lord, the additional list, my Lord, I was, my Lord, allowed to choose a place. And thereafter, my Lord, I chose, my Lord, the government polytechnic college, Kalaburagi, since it was a vacant place.
The counseling tara.
After counseling, it is, my lord, through all counseling, in terms of 2021 rules. And, my lord, here, on the other hand, my lord, the fourth respondent, my lord, he was liable for transfer, my lord, on compulsory transfer. My lord, once they complete their minimum tenure, they are liable for, my lord, compulsory transfer, and, my lord, they need to, my lord, choose their place, my lord, while counseling. My lord, the lists are separate. For compulsory transfer, the list is separate. For spouse prioritization case, the lists are separate. And, my lord, I was, my lord, first in the waiting list for spouse, in spouse category. My lord, wherein, my lord, one person, my lord, where she opted out, my lord, I entered and choose a place, and rightly I was given that place, my lord, and I was transferred there. In the meanwhile, my lord, this person, my lord, he was, my lord, liable for transfer, compulsory transfer. My lord, the prioritization cases have to be taken, like disability, spouse cases, and so on and so forth. Thereafter, my lord, the next day, my lord, the counseling for the compulsory transfers were taken.
Already exercised your option on the previous day.
Yes, my lord, previous day, on 12th,
You have already
already exercised, and I was given that place,
Where is that? How do you?
please. Page 58,
50?
58. My lord,
Serial number?
serial number, my lord, in spouse, zone C, serial number 1, Kalagade.
Shivraj.
Yes, my lord.
So you are given which place?
My lord, I was, my lord, here.
Polytechnic, Surpur,
My lord, this is, my lord, this is, my lord, Polytechnic, Surpur, my lord,
Yadgir.
this Yadgir district.
So this you have already been given.
No, my lord, this, my lord, the earlier place, my lord, where I was working, this is only in, my lord, a provisional list. Wherein, my lord, I was found to be, my lord, eligible for spouse category, my lord. Wherein, my lord, my name, my lord, provisionally, my lord, appeared, my lord, in this list. And thereafter counseling was, that after counseling, my lord, I was given place, that, my lord, at on 13/8. Annexure G,
Annexure?
G, my lord.
Raj, pause case. Mechanical general.
Annexure G is
My lord, that is the final, my lord, the transfer,
page
134. My lord, this is the, my lord, what had happened, my lord, on 12th, my lord, for priority cases, and my lord, on 13th, my lord, for the compulsory, my lord, the transfers. Both of them clubbed together, my lord, on 13/8 itself, my lord, the transfer list was released.
So
On
where is your name?
Yes. My name, my lord, appears in, my lord, insofar as internal page 18, page 152. My lord, this is the, my lord, the fourth respondent, serial number 245.
Page 150.
152, internal page, my lord, 18. Not
Where-
got it.
Where is your name here?
My lord, page, serial number 245.
245 is his name.
245 is his name.
Where is yours?
Yes. My name, my lord, appears in spouse category. '53, my lord. Internal page 5. Here, my lord.
Shivraj,
Yes, my lord. From Surpur, Yadgir
Yadgir to Gulbarga.
to Gulbarga. Now, my lord, in the first place, my lord, my lord, I had chosen my place, my lord, under spouse category.
Which place you had chosen?
My lord, to Gulbarga, Government Polytechnic, Gulbarga.
Now you're allotted there.
Yeah, allotted there, and I have been transferred. I am working there, my lord. In the meanwhile, my lord, next day he chooses a place, my lord, given for his choice. He chooses, my lord, some other place, Afzalpur. Even he is also, my lord, allotted his place. He also goes, my lord, and works. In the meanwhile, my lord, thereafter he files, my lord, an application saying as to, my lord, I am not eligible for, my lord, for such transfer. And in the event, my lord, that I was my lord, disqualified, in that event, my lord, that he would get a chance, my lord, to be transferred, my lord, to GPT Kalaburagi. That was his precise contention. And my lord, one of the main ground, my lord, what he had taken before the tribunal, my lord, is that, my lord, for the transfer, my lord, that it is a minimum 3 years. Insofar as, my lord, prioritization cases, it is 3 years in terms of the transfer rules. He says, my lord, that I have not completed my minimum tenure of 3 years. That is his, my lord, the precise contention. My lord, since, my lord,
You're working at Gulbarga since when?
no, my lord, I am working at Surpur, Yadgir. Since, my lord, in terms of annexure A1, that is, my lord, that is clear.
Now this order posting you to Kalaburagi was passed on 13/8/24.
Yes, very much.
When was it changed?
It is not changed, my lord. Till today, my lord, I'm still working there.
Now this has been set aside by the KAT.
Yes, my lord. That has been set aside by the KAT.
On what ground?
On the ground, my lord, that, my lord, I have not completed, my lord, 3 years, my lord, in, my lord, the earlier place. Now, my lord, lordship may kindly see the earlier, my lord.
Now you have been relieved or not yet?
No, not yet. My lord. I'm working there. Still, I'm working there. And this is, my lord, without hearing me. Before I could file wakalat. And, my lord, in the second hearing itself, it was disposed of. And, my lord, but in my lord, I was, my lord, my period, my lord, I had already, my lord, completed that 3 years. My lord, I could not demonstrate for the reason, my lord, that I was not given an hearing.
You have completed 3 years.
Yes, my lord, I very much completed 3 years.
When were you posted at Yadgir?
Surpur, my lord, yes. My lord, annexure C, page 114.
What is the date
Yes,
of you being posted?
my lord, date, my lord, on 29/7/2021.
So you have completed.
Yes, my lord. And
Just one. Now the tribunal holds it's a premature transfer.
tribunal holds, my lord, in terms of
Which
yes, yes.
Which para?
Annexure B, page 111, my lord, the ink page. My lord, 110, my lord, kindly.
Para 8 first.
Yes, my lord, para 8.
The petitioner has called in question the correctness, validity of the order in application 21291 of 2024, wherein his order of transfer at annexure G
Annexure G.
was set aside while observing that the petitioner had not completed the 3 years for being eligible for subsequent transfer. Pointed out that in terms of annexure on 29/7/21.
Yes, my lord.
In terms
Annexure
of annexure
B.
B, he was posted at Surpur, Yadgir district at the Polytechnic College on 29/7/2021. And if that were to be so, he had completed 3 years. And accordingly, the finding of the tribunal was erroneous. Full stop. Submitted that though there was delay in filing wakalat, the facts as made out above required to be taken note of. In light of the same, subject to further consideration, there would be stay of the order of the KAT.
Yes, ma'am.
At KAT till the next date. AGA accepts notice for respondent 1, 2, and 3. Emergent notice to the fourth respondent.
One small correction, my lord. It is, my lord, annexure C is my initial, my lord, where 29/7/221 is annexure C, my lord, not B,
Make sure see.
C.
Now we have finished our term and we're going to Bangalore.
He
Please.
is working.
But you are not leaving us.
Please,
He is working.
Sorry,
Your
ma'am.
lordship, then
I'm sorry.
staying. He is working there.
Yes, I'm working, very much working, my lord, in the,
Not stay.
Illa. I've been transferred in terms of this counseling has been given effect to. I'm working, my lord.
The continuance of the petitioner at his place shown at annexure G
Yes,
C.
would G
G.
would continue
please.
in the next day.
Great.
Of his objections to be complied with.
Please.
For 2004, there is a 4 years. My lordship.
3 years and
3 years, 4 years, and they are in 46 serial number
Illa,
46.
my lord,
He
in so-
himself is argued that.
My lord, insofar as, my lord,
Yes.
insofar as, my lord, the compulsory transfer is there, that is 4 years. In terms of prioritization, 3 years.
That is, yes,
Please.
yes.
It's already.
Number one, announcement of judgment, serial number 54, Shivanandvi Patan City.
Criminal appeals number 200113 of 2017 and 200133 of 2017 are hereby dismissed. Judgment of conviction, order of sentence passed against appellants, that is number 1 and 4, dated 28/3/2017 in SC number 73 of 2015 by the 4th Additional Session Judge Vijayapura is hereby confirmed. Send the operative portion of this judgment to the trial court by mail and back the trial court records.
Please.
Past door matters. Serial number 5, KM Gate.
Proxy counsel appearing on behalf of Kuman, respondent number 5 and 6, your lordships. Your lordships had ordered to make a survey. The survey report is ready. The council is out of town for some personal reasons, your lordships. It may be posted after vacation, immediately after vacation.
Relist on.
1610.
Obliged, lordships.
Serial number 6, Biradar Kalyani.
Respondent is present. Respondent is present due to,
Today, presence only is not sufficient.
Yes.
The reason for his presence.
I do agree, your lordship.
Ah,
Due
so
to
what we-
what he has said, your lordship, some medical emergency with his
No, that-
daughter.
No, that's okay.
I do
What
agree.
we are saying, suppose you had complied, his presence was not required. Now, how much you are going to pay?
So at present, he has given 5,000 rupees and filed yesterday. I have filed an affidavit, your lordship. The remaining whatever arrears of this order service on honorable court, within 2 months he will pay, your lordship.
80,000 arrears ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
It is there 1 year.
Order speaks, I'm not speaking.
Yes. Yes.
80,000 arrears ಅಂತ ಹೇಳ್ತಾರೆ.
Yes.
5,000 ಕೊಟ್ರೆ
Like within,
ಪಿಗ್ಮಿನ ಕಲೆಕ್ಟ್
no,
ಮಾಡೋದು.
that is not your, his situation is very worst situation here. He's in a very agriculturist coolie, your lordship.
ಕೊಡ್ತಲ್ಲ ಅವ್ರು ಹೆಂಡತಿ ಕೊಡ್ತಾ ಇದಾರೆ.
That is the dispute thing. That's the disputed thing, your lordship. The adultery is the main, which is
ಅಲ್ಲೇ ಕುತ್ಕೊಂಡು ನಾನು ಅಲ್ಲಿ ಹೋಗ್ತೀನಿ.
adultery is the main reason, your lordship, behind this, all those things,
His
your lordship.
attitude.
No, your
The
lordship.
court directs him to be present before the
No,
court.
he has,
He gave a money to you,
no,
give it to his wife.
No,
Today
no,
he
no.
don't want to see
no,
his
no,
wife.
it is not like that, your, it is not like that. I told him to be present today, but yesterday night he called me, sir, there is emergency.
So take proper steps, let him go inside.
No, your lordship, I will, he has filed affidavit, your lordship.
We have passed an order directing the trial court to go along according to law. So you file a application there along the process, you will be sent inside. Distress warrant ಇದೆ.
He's the only person,
Arrest warrant ಇದೆ.
he's, He is the only person earning family, your lordship. He is ready to pay, your lordship. He is not a, is,
ಜವಾಬ್ದಾರಿ ಇದೆ ಹೆಂಡತಿ ಸಾಕೋದು.
ಅದು if your lordship go through the facts, your lordship, very different facts are there in this matter, your lordship. Your lordship.
Now we are very much concerned about
Yes,
the arrears of
Yes, yours.
maintenance.
I agree, yours. I made,
Pay. You
I
are
may-
not, you are regularly irregular
no,
in
yours.
payment of the maintenance.
Have economic issues are there, you say. Economic problem. He is
He's
also
paying
facing
his wife.
financial problem.
He's ಅಷ್ಟವಲ್ಲೇ ಇರ್ಬೇಕು ಯಾರೇ ಇರ್ಬೇಕು. He's paying to his wife. 80,000 ಬರೀ 5,000 ಕೊಡ್ತೀನಿ.
In 2 months, entire amount will be paid including.
To pay substantial amount.
I will make him to pay.
Okay, then we requested you to direct your client to pay a substantial amount.
Yes, your. Having some problem, your lordship.
Charity, sir.
Some medical emergency for that is not.
A charity. Your client is not doing any charity to his wife. Google biಡಿ, let him take steps, otherwise we'll send him inside.
He will- He has undertaken your lordship to deposit them.
First of all, he has no regard for the court.
That is not the pen.
He has no regard for the court order.
He has filed your affidavit. Affidavit.
Failed to pay the arrears of maintenance ordered by the trial court. He has evaded to come before the court today, though directed by the court,
Due to some
by the division bench rather.
that is emergency.
Yes.
Some emergency he has quoted your lordship. Nothing, not intentionally your lordship.
Emergency ಏನಿದೆ?
How he has.
ಈಗ ಹೇಗೆ ಜೋರ್ ಮಾಡಿದಾಗ ಹೇಗೆ ಬಂದ?
Like he was with
ಅಂತಂದ್ರೆ ಏನು
his
ಬಿಟ್ಟಿದ್ದೇನೆ?
daughter is pregnant, your lordship, and he went her to take away to his native. For that reason, he was in his daughter's house. For that reason, when I called him, sir, ille din barta idin antenu.
Excuses.
That is not, it is a fact. It is fact, your lordship, not any excuse for that.
ಈಗ ಸಾಯಂಕಾಲ 5 ಗಂಟೆ ಒಳಗೆ ಎಷ್ಟು ಕೊಡ್ತಾನೆ ಕೇಳಿ. 5,000 we are not satisfied.
But the thing is,
ಬೇಕ್ರಿ ಗಂಡ ಒಂದು ಕಡೆ ತಾನು ಒಂದು ಕಡೆ.
the facts are quite different, your lordship, that is it.
He has to pay substantial amount. He has to pay substantial amount.
Sir, on my part, your lordship, I will make it.
Third, at least 1/3. ಅದು ಆಗಲ್ವಾ? 5,000 ಏನ್ ಬರ್ತದೆ ಹೇಳಿ?
ಅಲ್ಲಿ ಏನ್ ಬರೋದ್ ಪ್ರಶ್ನೆ ಇಲ್ಲ ಮಾಸ್ವಾಮಿ. He is also having some problem. Agriculturist ಇದಾನೆ.
He may be having 100 problems. It is his duty to maintain his wife.
Only interim maintenance granted earlier, your lordship.
ಅದೇ
That the 120.
ತಿಳ್ಬೇಕಲ್ಲ.
ಕೊಡ್ತಾ ಇದೀನಿ sir.
ಯಾಕೆ ಬದುಕಬೇಕು? ಭಿಕ್ಷೆ ಬಿಡ್ಬೇಕಾ ಅವರು?
Facts are quite, adultery allegations are there, your lordship.
ನಾವು 4:30 5 ಗಂಟೆ ತನಕ ಟೈಮ್ ಕೊಡ್ತೇವೆ. ಎಷ್ಟು ಕೊಡ್ತಾನೆ ಕೇಳಿ.
I will make him measure. ಕೇಳ್ತೀನಿ sir. I will make it.
He has to pay substantial amount.
I will ask them out.
The number 14. Pulia payroll.
What is this matter?
Lord, this is the transfer matter, my lord. The respondent herein, my lord, who is the applicant before the honorable tribunal, my lord. Premature and without posting, my lord, the transfer order has been called in question before the honorable tribunal. My lord, during pendency of the application, my lord, the posting order has been given to the applicant. Then, my lord, again, the subsequent order also has been called in question, my lord, in the subsequent application. 2 applications were filed, my lord. The honorable, my lord, tribunal, my lord, after considering the merits of the case, my lord, allowed the application and set aside, my lord, the transfer order, and also, my lord, the posting of the applicant in the subsequently, my lord, who applicant is, my lord, in the cadre of, my lord, Tahsildar grade 1, wherein, my lord, posting is given to the lower cadre, my lord, which is required to be filled up, my lord, to Tahsildar grade 2, as protocol Tahsildar grade 2, my lord. Therefore, my lord, on the, and the post which is required to, my lord, the applicant is holding Tahsildar grade 1, whereas, my lord, the petitioner herein, my lord, he is a grade Tahsildar grade 2. Therefore, my lord, he is not eligible to hold the post of Tahsildar grade 1. On that ground, my lord, the applications were allowed. Now, against which, my lord, the respondent therein, my lord, the petitioner approached.
No, but where were you, where is the original order of transfer? He's
Yes.
posted in your place.
Yes, my lord.
Where are you posted?
My lord, I was not given any posting, my lord, in the first instance.
No, where is the first order of transfer?
Yes, my lord. Annexure, my lord. Annexure AS7, my lord.
Page?
Or page number 26, my lord. Annexure A3. Serial number 11.
26.
Yes, ma'am.
Now, in terms of this order,
Yes, ma'am.
what's your name?
My lord, my name is Nagamma,
Serial number?
11, my lord. K. Anand Shil is the petitioner herein.
Huh,
My lord, I am Srimati Nagamma, my lord.
huh.
ಇವರ ಸ್ಥಳಕ್ಕೆ ಆನಂದ್ ಶೀಲ್ ತಹಸೀಲ್ದಾರ್ ಗ್ರೇಡ್ 2 ಪ್ರಸ್ತುತ ನಿಯೋಜನೆ ಮೇಲೆ ಕಾರ್ಯದರ್ಶಿ ಕಲಬುರಗಿ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಕಲಬುರಗಿ ಇವರು ತಹಸೀಲ್ದಾರ್ ಗ್ರೇಡ್ 1 ಕಲಬುರಗಿ ತಾಲೂಕು ಕಲಬುರಗಿ ಜಿಲ್ಲೆ ಶ್ರೀಮತಿ ನಾಗಮ್ಮ ಇವರ ಸ್ಥಳಕ್ಕೆ.
Correct. Now, you were working at Tahsildar grade 1 at Kalaburagi.
Yes.
For how long? Since how long you are working?
My lord, as per annexure A1, my lord, from 28/7/23, last 1 year.
So it's a premature transfer.
Yes, ma'am, premature transfer. Premature and my lord, as per annexure A3, without posting, my lord. No posting order has been given to the applicant. Therefore,
So you challenge this?
yes,
Saying it's premature
premature
and
and
there's no posting.
yes.
Now that has been set aside.
My lord, during pendency of this application, posting order has been given, my lord.
And that's one part.
Yes, my lord.
So, but your ground of premature was upheld
Yes, my lord.
and the tribunal has set aside this order,
Yes, ma'am.
Huh?
Yes, my lord.
which he has challenged.
Yes, ma'am.
Yes.
Lord, annexure E, Lord will peruse page number 88.
And before that, my lord, one submission. Since 2 applications were filed before the honorable tribunal, my lord, common order has been passed.
2 applications, why?
Because subsequent posting order is also called in question, my lord, in the another application.
You were challenged.
Yes, my lord. Because I have been posted to the lower cadre, my lord.
No, 1 minute. You were, where were you post? Where is the posting?
Yes, my
order?
lord. That is, my lord, at page number 88, my lord.
Page 88.
Yes, my lord. That is called in question in application number 20857 of 24. Page number 88, annexure E.
So you are posted as
As a, my lord,
protocol.
ಖಾಲಿ ಇರುವ ಶಿಷ್ಟಾಚಾರ ತಹಸೀಲ್ದಾರ್ ಹುದ್ದೆಗೆ ಸಾರ್ವಜನಿಕ ಆಡಳಿತ ಹಾಗೂ ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ತಕ್ಷಣಕ್ಕೆ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಾಗೂ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿ ಆದೇಶಿಸಿ.
Tahsildar protocol where?
At Gulbarga, my lord.
DC
Office
office.
of Deputy Commissioner,
office.
Gulbarga.
Office of DC.
Yes.
Now your original displacement was from
Tahsildar grade 1, Kalaburagi Taluka.
same Kalaburagi only.
Yes.
Huh?
Yes, ma'am.
Same place.
Yes.
Same place.
My lord, as per annexure A1, I was working as Tahsildar grade 1 at Kalaburagi Taluka, my lord. Now, my lord, posting has been given at the office of the Deputy Commissioner as Tahsildar protocol, my lord.
Same place.
No, my lord. It is in the office of Tahsildar, Tahsil office, my lord. This post, my lord, subsequently given posting at the office of Deputy Commissioner.
Shistachara.
Ado protocol of Tahsildar. Both offices are different, my lord. That is, my lord, office Tahsildar Taluka.
Same city.
Same Gulbarga. Yes, my lord. And this, my lord, the post of, my lord, the Shistachara Tahsildar, it is, my lord, grade 2. Tahsil.
Yes, what do you say? He transfers is a nuisance.
And 2 writ petition, my lord, 2 applications were filed. Now,
ಇನ್ನು ಜಾಸ್ತಿ ಮಾತಾಡಕ್ ಆಗಲ್ಲ ಇವತ್ತು.
Lord,
ಇವತ್ತು ನಾವು ಜಾಸ್ತಿ ಮಾತಾಡಕ್ ಆಗಲ್ಲ. ಎಲ್ಲಾ ಕಡೆ ಪ್ರಸಾರ ಆಗ್ತದೆ.
live stream.
Yes, so now what is your case?
Lord, I request my lord to, ಆಯ್ತಾ ನಿಮ್ದು? If submission is over, I will start. Annexure E, page number 91.
Page
91. As at page number 93, lords will find my transfer order. 94, item number 24 is my name. This transfer order is issued on 11/10/2023. 11/10/2023.
you were transferred to
Gulbarga, Kuda, Kalaburagi Urban Development Authority as a secretary. I request my lord to peruse item number 24, page number 94. So and so ಟ್ರಾನ್ಸ್ಫರ್ ಟು ಕಾರ್ಯದರ್ಶಿ ಕಲಬುರಗಿ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಕಲಬುರಗಿ ಇಲ್ಲಿಗೆ ನಿಯೋಜಿಸಲು ಇವರ ಸೇವೆಯನ್ನು ನಗರಾಭಿವೃದ್ಧಿ ಇಲಾಖೆಯ ವಶಕ್ಕೆ ನೀಡಲಾಗಿದೆ. Followed by this, I have handed over the charge, got relieved, came from my place. That is Tahsildar Lakshmeshwar, grade, my lord will find on page number 96.
So you reported for duty at Kalaburagi. You reported for duty as the
That is
Kalaburagi
what I wa-
Development Authority.
That is what I wanted to submit, my lord. I have not reported. Now I am not allowed to, my lord, join. I approached KAT till today. My lord, till this transfer order is issued, I was on the road. That is what I want to submit, my lords. Page number 96. My lord will see right side, first box. So and so, Tahsildar Lakshmeshwar, grade 1. This is my CTC. I got transferred, relieved.
Page.
96. 96.
ಪ್ರಭಾರ ವರ್ಗಾವಣೆ ಪತ್ರ.
I got relieved. 98. My lord will turn to page number 98. I have requested the authority concerned to permit me to join the duties. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನನ್ನನ್ನು ತಹಶೀಲ್ದಾರ್ ಲಕ್ಷ್ಮೇಶ್ವರ್ ಹುದ್ದೆಯಿಂದ ಕಲಬುರಗಿ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಕಚೇರಿಯ ಖಾಲಿ ಹುದ್ದೆಯಾದ ಕಾರ್ಯದರ್ಶಿ ಹುದ್ದೆಗೆ ಉಲ್ಲೇಖ 1ರ ಆದೇಶದ ಮೂಲಕ ವರ್ಗಾವಣೆ ಮಾಡಿ ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ದಿನಾಂಕ 17/10/23ರಂದು ಲಕ್ಷ್ಮೇಶ್ವರ್ ತಹಸೀಲ್ದಾರ್ ಪ್ರಭಾರ ನೀಡಿ ಸೇವೆಯಿಂದ ಬಿಡುಗಡೆ ಹೊಂದಿರುತ್ತೇನೆ. ಪ್ರಯುಕ್ತ ಕಲಬುರಗಿ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಕಚೇರಿಯ ಖಾಲಿ ಹುದ್ದೆಯಾದ ಕಾರ್ಯದರ್ಶಿ ಸೇವೆಗೆ ಹಾಜರಾಗಲು ಅನುಮತಿ ನೀಡಲು ಮಾನ್ಯರಲ್ಲಿ ಕೋರಲಾಗಿದೆ. Followed by Lord, page number 99, District Minister writes to the concerned minister. I request my lord to turn page number 100. District Minister writes to the concerned secretary. Thereafter, I had to approach KT. My lord will find on page number 101. Right from October, Lord, till June, till this KT order is passed, I was not given posting. Even after this order, no posting was given. Finally, as per Annexure A3, what the other side submitted, I have been transferred to Kalaburagi as a Tahsildar grade 1. Lord will find Annexure A3, page number 26.
So you are saying even otherwise, even yours is premature.
Lord,
You're saying that even yours transfer from Kalaburagi Urban Development Authority is again premature.
not allowed to join. Not allowed to join. Right from October to this 31st July, I was not given posting. I was running between the pillar to post. District Minister recommended to the concerned minister to give me posting. Secretary, a letter is given. No. Finally, as per Annexure A3, page number 26, a transfer order came to be issued on 31st July 2024, where I have been transferred and posted to the present place, where the other side is contending that grade 1, grade 2. I will come to that point also. My lord will find item number 11. My name finds place.
Page.
Page number 27.
Yes.
Item number 11.
Yes.
I am posted as Tahsildar grade 1, Kalaburagi Taluka, in place of private respondent. Followed by this, my lord, I joined the duty. My lord will find page number 111.
As on date, you are working there.
My lord,
As on date,
I am working. I have received the salary. I have produced salary slip from the Accountant General. Page number 111, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ನನಗೆ ಕಲಬುರಗಿ ತಹಶೀಲ್ದಾರ್ ಗ್ರೇಡ್ 1 ಹುದ್ದೆಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಿ ಆದೇಶಿಸಿರುತ್ತಾರೆ. ಮಾನ್ಯ ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ಇಂದು ದಿನಾಂಕ 1/8/24ರಂದು ಪೂರ್ವಾಹ್ನ ಕಲಬುರಗಿ ತಹಶೀಲ್ದಾರ್ ಗ್ರೇಡ್ 1 ಹುದ್ದೆಗೆ ಹಾಜರಾಗಲು ಅನುಮತಿ ನೀಡಬೇಕಾಗಿ ಮಾನ್ಯರಲ್ಲಿ ಗೌರವ ಪೂರ್ವಕವಾಗಿ ಕೋರಲಾಗಿದೆ. Followed by in the bottom, permitted. Deputy Commissioner has permitted me to assume the charge of Tahsildar of Kalaburagi Taluka. Thereafter, from that day onwards till today, I am discharging the duties of the Tahsildar. Now, the other side has been contending that grade 1, grade 2. I request my lord to peruse page number 112.
1,
112, page number 112. There has been circulars from time to time. This is the latest circular where government says, ದಿನಾಂಕ 8/7/24 ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಯವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ರಾಜ್ಯದ ಎಲ್ಲಾ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳ ಸಭೆ ನಡೆಸಲಾಯಿತು. ಸದರಿ ಸಭೆಯಲ್ಲಿ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಜನರ ಸಮಸ್ಯೆಗಳಿಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಸಕಾರಾತ್ಮಕವಾಗಿ ಮತ್ತು ಗುಣಾತ್ಮಕವಾಗಿ ಇತ್ಯರ್ಥಪಡಿಸಲು ಹಾಗೂ ಜಿಲ್ಲಾ ಮಟ್ಟದಲ್ಲಿ ಯೋಜನೆಗಳ ಪರಿಣಾಮಕಾರಿಯಾಗಿ ಜಾರಿಯಾಗುವಂತೆ ಸಮನ್ವಯತೆ ಸಾಧಿಸುವಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವ ನಿಟ್ಟಿನಲ್ಲಿ ತಮ್ಮ ಅಧೀನ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳಿಗೆ ಸೂಕ್ತ ನಿರ್ದೇಶನ ನೀಡುವಂತೆ ಸೂಚಿಸಲಾಗಿದೆ. ಅಲ್ಲದೆ ಕಚೇರಿಯಲ್ಲಿ ಉತ್ತಮ ಕಾರ್ಯಕ್ಷಮತೆ ಶಿಸ್ತು ಪಾಲಿಸುವಂತೆ ಕ್ರಮವಹಿಸಲು ಮತ್ತು ಒಂದು ವೇಳೆ ಈ ದಿಶೆಯಲ್ಲಿ ನಿರ್ಲಕ್ಷ್ಯತೆ ತೋರಿದ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳ ಮೇಲೆ ನಿಯಮಾನುಸಾರ ಸೂಕ್ತ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಸಹ ಸೂಚಿಸಲಾಗಿದೆ. ಯಾವುದೇ ಅಧಿಕಾರಿ ನೌಕರರ ಬಗ್ಗೆ ಅಸಮರ್ಥತೆ ಅಥವಾ ದೂರುಗಳು ಇತ್ಯಾದಿಗಳ ಕಾರಣದಿಂದ ಅವರನ್ನು ವರ್ಗಾವಣೆ ಮಾಡಲು ಅಥವಾ ನಿಯಮಾನುಸಾರ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಅಗತ್ಯವಿರುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಳಿಸುವಂತೆ ಸೂಚಿಸಿದೆ. ಹಲವು ಅಧಿಕಾರಿಗಳು ಮತ್ತು ನೌಕರರು ಒಂದೇ ಕಚೇರಿ ಅಥವಾ ಒಂದೇ ಸ್ಥಳದಲ್ಲಿ ಅವಧಿ ಮೀರಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವುದು ಅಲ್ಲದೆ ಇಂತಹ ಹಲವು ಅಧಿಕಾರಿಗಳು ನೌಕರರುಗಳ ವಿರುದ್ಧ ದೂರುಗಳು ಸಹ ಸ್ವೀಕೃತವಾಗಿರುವುದು ಸರ್ಕಾರದ ಗಮನಕ್ಕೂ ಬಂದಿದೆ. ಆದ್ದರಿಂದ ಒಂದೇ ಹುದ್ದೆ ಸ್ಥಾನದಲ್ಲಿ ಅಥವಾ ಒಂದೇ ಸ್ಥಳದಲ್ಲಿ 5 ವರ್ಷ ಮೀರಿ ಮುಂದುವರೆದಿದ್ದಲ್ಲಿ ಮತ್ತು ಅಂತಹವರ ವಿರುದ್ಧ ದೂರುಗಳು ಏನಾದರೂ ಇದ್ದಲ್ಲಿ ಅವರ ಅಧಿಕಾರ ಅವಧಿಯ ವಿವರಗಳೊಂದಿಗೆ ವಿವರವಾದ ಪಟ್ಟಿಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಕಳುಹಿಸಲು ಸೂಚಿಸಿದೆ. ಇದನ್ನು ಆದ್ಯತೆಯ ಮೇರೆಗೆ ಎಂದು ಪರಿಗಣಿಸುವಂತೆ. ದಿಸ್ ಹ್ಯಾಸ್ ಬಿನ್ ಇಶ್ಯೂಡ್ to the heads of the districts, Jilla Panchayat as well as the district committee authorities. If any of the officers working under them, if they are found to be something, their reports are to be sent. This is the GO is in force today. The private respondent has been submitting that she is handicapped. She is handicapped. And moreover, she has come from Yadgir to Kalaburagi 1 year back only. Her minimum stay is 2 years. She wants to continue and stay there for 2 years. It is the discretion of the government authorities to whom to place, to whom to not to place. After assuming charge by this petitioner has been taken to Kalaburagi Taluka as well as Afzalpur Taluka to combat the circumstances situation of Bhima River floating. Tahsildar has put his services to night and day for rendering service to the public who are on the banks of Bhima River. Followed by this, my lord, I request my lord to peruse Annexure G, Annexure H, Annexure H, page number 148.
You have not yet relieved.
Page number, my lord.
You have not yet relieved.
No, I joined and running.
As on date.
No. Page number kindly see for my satisfaction. Annexure number, Annexure H, page number 148.
Page 14.
148. Additional document I have filed. Page number 148.
When you have filed later.
No, together I have filed. Page number 148. My lord will see second box. Transfer 1/8/2024. Lord, this is the salary slip of mine for having done the service as a Tahsildar grade 1 in Kalaburagi Taluka. Lord,
148 ಬೇರೆ ಇದೆಯಲ್ಲ.
148 pay slip.
47.
Yes.
This is, my lord, a proof in support of my having served as a Tahsildar for the month of August. Followed by this, my lord, I request my lord to peruse Annexure J, where the 17th September.
So let us see now. It has to be heard finally. So maintain status quo as on date.
My lord, may I submit, my lord? My lord, when I got the interim order of status quo, my lord, by that time he assumed the charge, my lord. I did not hand over any charge, my lord. He assumed the charge. By virtue of that, my lord, the interim order which I have obtained, my lord, which goes against me, my lord, status quo, because he is working there, my lord. Now, my lord, in spite of, my lord, the dismissal of the, upheld of the transfer order by the honorable, my lord, tribunal, my lord. My lord,
No, correct. That will hear the matter. Now, as on date, whatever status quo remains, let it be, we'll put it on 15th. And then you let the government take instruction, we'll see what.
My lord, all the records are there, my lord, because
We can't hear now and pass an order. We have parted matters. We were just seeing anything. Now, if he's working as on date and not relieved, status quo as on date to be
my lord,
maintained.
not relieved, that question does not arise because he has assumed the charge, my lord.
Validity of that order is to be challenged.
My lord, your lordship, kindly see page number 90, my lord.
No, we are testing the validity of this order.
Yes, my lord, it is clear, my lord, page number 90, my lord.
No, but we don't want to dispose it of today.
Lord, at least for interim order, my lord, let it, my lord, for consideration of interim order, my lord, on 15th, my lord. Till then, my lord, there may not be any interim order of status quo because ultimately it goes help to the, my lord, the petitioner, my lord.
That's
Even
why-
though, my lord, I got the interim order before the honorable tribunal, my lord, the status quo order, none again, my lord.
I've got that order enforced. If there's an order of status quo before the tribunal,
By that time, my lord, he has assumed the charge, my lord.
that we don't know. Yes, what do you say?
My lord, page number 90.
My lordship again, take the instruction, my lordship, what happened? Because whether he has taken charge or not, I will verify. My lord.
He's working there, he said.
Yes, my lord, we as per an.
He also says.
He got salary also, my lord.
He working, my lord, yes, it is admitted fact, my lord, he is working. But, my lord, page number 90, my lord, my lord, I have been posted, my lord, to the Tahsildar grade 2, my lord.
No,
My lord, I have no objection, my lord, your lordship may direct, my lord, for posting of the petitioner, my lord, to any suitable post.
Given posting already.
That's a matter, final orders are passed, that some decision will have to be taken. Now, as it is, we have to continue it, and then both of you argue it out on the reopening day. That's all we can say. We don't want to upset whatever status quo that is there as on date. Because we have to pass. a
But, my
reasonable-
lord, there is no prima facie case, my lord, for granting of any interim order, my lord.
That we'll see.
Because he is not eligible, my lord. I have, my lord, the judgment.
He's not my master.
The person cannot
not
be
my
posted to
master.
a higher rank
That we
here,
have
my
to
lord.
hear. That we have to hear. Status quo as on date till the next date, let the government take its stand, and then you, both sides, you let it be heard. Now, you are not working there since how many months?
August, since when I took charge, from the date of my taking charge.
Let us. The,
For consideration, it may be posted for
Yes, yes.
consideration of
Yes.
interim.
in light of paucity of time, as the matter has been listed on the last day of the present roster, as it is admitted that the petitioner is at present working as
Tahsildar grade 1 at Kalaburagi Taluka.
Tahsildar grade 1 at Kalaburagi
Taluka.
Taluka. There would be an order of status quo to be maintained till the next date. Making
Grateful.
it clear that this
Grateful.
order is open for variation on the next date upon submissions by the state as well as the respondent. Read is the matter on 14th.
Please.
Grateful.
Bill number 70, Satyam Pawan Kumar, Satyam Pawan.
In fact, we had met Mr. Mantesh Patil.
What is the point? What is the point?
But the point is that the construction permission is cancelled by the authority and the learned single judge has allowed the repetition of the other side herein. On the assumption that a civil suit filed earlier has rendered a finding that there is no road there where we are saying that there is a road where he claims to have a plot there. But that civil suit has been, my lords, subject matter of a regular, where this honorable court has held that the authority is at liberty to take action as per law to decide whether there is a road or not. This finding that there is a road or no road in a civil suit at the behest of one person will not come in the way of that. Now, my lords, your lordships had heard me on the last occasion. Your lordships wanted to consider the interim prayer, where he wanted to ascertain whether he will give an undertaking that he will not construct or not.
Quotal number 4, kindly pass over.
My friend had told me that he has instructions to say that his client is not intending to put up any construction as
So
of.
if you were to undertake that till the next date, you won't put up construction in that disputed place, we'll record that and have it,
Engineer will make submission, kindly pass over, my lord.
you bring him
Please, ma'am.
and
The,
inform him.
Please.
Pass over.
Grateful.
Yes. Next.
Number 19, Satyan Shivagi
Where is your
Yes, I
friend?
tried, my lord, is not reach out of coverage area,
Huh? Ilva?
out of coverage
Is
area.
there-
my lord.
Then will have it on the reopening day.
Yes, my lord, but
Office to show. the
permission,
name.
I have for, so and permission to prosecute may be allowed. Then if they issued any notification, my lord, in the meanwhile, when I for liberty to move before the occasion bench,
Yes, learned counsel Shri Venkatesh C. Mallabadi. Huh?
please,
Is directed to accept notice for respondents,
respondent to bank.
one and for the respondents 1, 2, 1, 2, 3.
Respondent 5, my lords.
Respondent 5, huh?
Yes, my lords.
For respondent number 5.
Yes.
Appellant is permitted to serve the counsel who appeared in the.
Already I've served the copy, my lord.
writ
Same last
proceedings
weekend.
as regards respondents 1 to 4. Office to show the name of counsel who appeared in the writ proceedings as representing the respondents. Liberty is reserved to the appellant to move before the vacation bench if there is any further development in the interregnum.
Please,
Relist the matter on.
1510,
please.
Yes.
seal number 20, Nitesh Padyal.
I given notice to my friend.
Yes.
Lordship. The short question which will be for Lordship's consideration is
It's dismissed only on the question of jurisdiction.
not dismissed, my lord.
No, that's
Disposed with a liberty to approach CAT.
only on the point of jurisdiction.
How, sir? My submission is that, my lord, I am not a regular employee. And earlier two decisions of this honorable court, same facts and in respect of the same respondent, my lord. And my humble submission that the learned single judge is supposed to follow the judgment of single judge. He cannot disagree or go contrary. I am not.
Yes, what do you see?
Lord, I submit.
Hmm.
This point was raised, Lord, this judgment was referred to, Lord, before the Honorable, Lord, single bench. Lord, in this case, there is no question of decided whether the writ petition is maintainable or not. There is no any whisper about that. This Honorable, Lord, learned, Lord, single bench rejected this writ petition stating that I am not deciding the case on merits. I am holding that only, my lord, the writ petition is not maintainable. I have produced, my lord, several judgments of this honorable court, wherein they hold that the ESI employees has to approach this, my lord, CAT as per the Administrative Tribunal Act. So based on that, my lord, the honorable court said, I will not touch on the merits. I can, my lord, give a liberty to approach within 4 weeks. Hence, my lord, the honorable court has decided the writ petition is not maintainable and approach the CAT, and further interim order, my lord, 4 weeks is extended. And this judgment is, my lord, rejected by though it is not mentioned in the, my lord, order, but the very same submission has been made before the honorable, my lord, single bench also.
My only submission, my lord, can the learned single judge disagree with the coordinate bench decision? I am not pressing for regularization, my lord. I will be pressing for not to replace me. And that is and they have not preferred any appeal, my lord, on earlier 2 occasions. That has attained finality. Now the problem is, my lord, my prayer is not for my appointment. I am confining my prayer only for not to replace me with the same set of temporary employees. By following this judgment, my lord, I have also filed honorable division bench decision of this honorable court, my lord. By following Hargur Pratap Singh case, I am not seeking regulation. That prayer may be kept in abeyance, my lord. My only, your lordship may kindly peruse. My appointment was temporary, my lord. I will not be following or covered C&R regulations.
So you're saying the interim relief you're seeking for the present is not to be replaced by
Astes.
other than
Let-
regular.
They are at liberty to appoint a regular employee. I cannot seek also. I am fairly conceding. The Hargur Pratap Singh case, my lord, temporary shall not be replaced by, the division bench judgment is also there, my lord. I have filed it.
What is the main prayer in your writ petition?
Main prayer I am not pressing, my lord.
No, what was the? prayer?
Regularization and subsequently there was amendment, my lord. Incidentally due to Corona, my lord, that even in the writ appeal also, my lord. I beg your pardon. The unamended writ petition has been filed, my lord. Though it was amended writ petition was filed long back.
Hello,
Seems-
You have filed the appeal, isn't it?
House, sir, house. My prayer is not for regularization. I will not be pressing for regularization. I am not
To
pressing.
appear for?
Yes, I know.
Yes, sir. please. No, this, you're saying this point has not been considered here.
No, my lord, that judgment has been given before the, my lord, honorable single bench also. My lord, straight away, the honorable court rejected on the ground that that case is now decided on the point of maintainability. There is no discussion. Whether if any, my lord, this matter was taken up, not no single sitting, 2-3 sitting, but honorable court given an opportunity to the other side to produce any judgment so that, my lord, writ petition is maintainable against the ESI. They have produced only this judgment stating that this honorable court already taken a view. Thereafter, this honorable court holds that, my lord, in that case, they have not decided whether writ petition is maintainable or not maintainable, since they allowed it. But question of, my lord, limitation not been decided, hence I will not look into that judgment. And, my lord, further, your lordship may kindly say what they are stating is that the temporary employee cannot be replaced, which is, my lord, a wrong concept. Your lordship may kindly see the paragraph 5 of the, my lord, judgment of the Supreme Court. They reverse that, my lord, Hargur Singh case, the law. Kindly see, my lord, paragraph 5 of the, my lord, judgment. May I permit you to read? It may be mentioned that there is no principle of law that a person appointed in a temporary capacity has to be right to continue till regular selection. Rather, a legal position is just reverse. That is that a temporary employee has no right to the post wide the state of UP and so on so. Hence, he has no right to continue even for a day as for right from having a right to continue till regular appointment. Lord, subsequently Supreme Court, my lord, in the several judgments state that the regular temporary employee cannot say that, my lord, to replace another temporary employee, he has a right to continue. This is, my lord, 2008.
Now, have you removed him? Have you removed him?
Yes, my lord.
They have not removed, my lord. Even the order of London single judge says
No,
that
just one.
I was since
my lord.
2021, my lord, I have been in service.
My lord, what, my lord, in this case, what they have done, kindly see my statement of objection, page number 143, your lordship.
Order node.
143, your lordship may kindly see how this writ petition is filed and how the interim order is obtained.
Huh?
Oh, yes, it is in my written statement, my lord. Kindly see page number 143. I have produced the review orders. Kindly see already they have been reviewed on 7/7/2021. Lordship, kindly see note, my lord, this date, my lord. The writ petition is filed. Interim order was obtained on 4/8/2021, my lord. By suppressing this relieving order, what they prayer in the, my lord, writ petition, your lordship, kindly see, they have not sought for, my lord, stay of this relieving order. They sought an order. Annexure A is the, my lord, order of the a notification was issued by the ESI for calling for the certain post. That order has been stayed, and my lord, further they have, my lord, got an order that not to relieve from the post. Before passing an interim order, my lord, already they have been relieved on 7/7/2021 itself. But however, this honorable court says that since the interim order is there, my lord, to respect the interim order, we have been, my lord, continued. I am not saying that we have removed it, we continued. In spite of the relieving order passed before the interim order,
but interim order was passed after that, my lord, this relieving order is not brought before by the, my lord, other side.
What do you say regarding jurisdiction?
Jurisdiction, my lord, I have the, my lord, several
Daily wage
judgment.
employee, my lord, he is.
Maybe daily wager, maybe, my lord, the, once they have questioned the, my lord, appointment of notification. Once, my lord, ESI notification has issued, my lord, as per the central notification, ESI adopted the, my lord, CAT. That is, my lord, I have stated. Lordship, I can place, my lord, the other several judgments in this, same, my lord, ESI only. This honorable court has, my lord, taken.
On the point of jurisdiction.
Yes, ma'am, on the point of jurisdiction. There, the honorable court has referred to, my lord, the notification also in that case.
Paragraph?
Lord, paragraph 3 onwards, my lord, your lordship may, however, the respondent on appearance have filed an objection that has a preliminary objection as a maintainability of the writ petition on the ground that petitioner are seeking a relief concerned with the service matter of respondent establishment, which is wing of Government of India. All such matters are amenable to the jurisdiction of Central Administrative Tribunal. In view of the provision of section 14 of the Administrative Tribunal Act and also notification, Lord, dated 2/5/1986, issued by the Ministry of Personal Public Grievance and Pension, Government of India, bringing even the second respondent under the purview of the Central Administrative Tribunal. He further has relies on the decision of the apex court in reported in so and so. When the apex court has, on consideration of the earlier decision of the Constitution bench at para 13, has observed thus. In view of the such repeated, my lord, paragraph 4, in view of the notification as well as in view of the decision of the apex court, the issue in these writ petition being related to the service condition of the petitioner.
All matters are being entertained by the CAT.
Yes, my lord. Yes,
Size.
yes, my lord.
All.
May I submit, my lord? The para 1 and 2 of the judgment which has been referred by my friend. The petitioners have sought for a declaration declaring that the action of the respondent not issuing the appointment letter. Internal page 3. Declaring that the action of the respondent in not issuing the appointment letter and empanelling the petitioners on the sole ground of non-production of certificate of registered nurse and midwife is illegal and arbitrary and unconstitutional. It is not in dispute that the petitioners have sought for an appointment in the respondents. I am not seeking appointment.
No. ESIC disputes come under CAT. That is the.
I am not disputing, my lord. My humble submission, then your lordship may kindly. Here, 2 honorable judges of this honorable court only in similar circumstances in respect to the same respondent. They have said, my lord, that insofar as regulation, I may not be entitled. Insofar as replacing me with the same.
No, jurisdiction, we are on the point of whether the jurisdiction is the
ಅದೇ
CAT.
ಬರ್ತದೆ ಸರ್, ನಾನು ಹೇಳೋದು
No, where is? now this-
ಟೆಂಪರರಿ ಅಲ್ಲ, ಅದರಲ್ಲಿ 2 ಜಡ್ಜ್ಮೆಂಟ್ ವಿಚ್ ಐ ಹ್ಯಾವ್ ಸಬ್ಮಿಟೆಡ್, ಮೈ ಲಾರ್ಡ್.
No, that's on merits. We are on the point of jurisdiction.
ಅಲ್ಲ ಸರ್, now the problem is jurisdiction.
How is the writ petition maintainable?
ಅದೇ ಸರ್, your lordship may kindly CCA rules. Application. Central Civil Service Rules. These rules shall apply to every government servant, including every civilian servant, government servant in defense service, but shall not apply to any railway employee, any member of IAS, any person in casual employment. My lord, it is only for this reason, even in the KCSR, my lord. KCSR also, same provision is there, paramaterial. And it is for that reason, number of thousands together cases have been filed before the labor court, daily wage employees. If they say that KCSR is applicable, CCSR applicable, your lordship may kindly peruse the appointment order. Your lordship kindly. Now we will be laying down the law. That is.
No. If they are on contract basis, let it be decided. Let the court.
It has to be decided. Your lordship will have to.
This honorable court, since merits, before the, my lord, single bench, they said they will approach and sought, my lord, 4 weeks time to extension for the period.
No,
And
that's what-
now again filing a writ appeal.
Yes, he will fix a date.
Any day, my lord. With a condition, my lord, if I seek adjournment, then let there be observation that the stay order
That's
maybe
what-
stands vacated.
So and so accepts notice for the respondent, one,
Not approve.
two, one, two,
Not, one and two, and three, my lord. 1, 2, 3.
to three, emergent notice to the other respondents. List the matter on
Any day.
23rd. Status quo as on date to be maintained till the next day.
IA for direction. Stay or IA for direction. That is, they have issued the notification for appointing temporary person once again. That I had challenged before.
Let it status quo in so far as you
Ah,
be maintained as on date.
Please, oblige, much oblige.
Status quo. The status quo as regards the petitioner. Appellant.
ಇದು
to be
ಕೊಟ್ಟಿವಲ್ಲ,
maintained
amended.
till the next date. ಅದು continue ಮಾಡು, ಬೆಳಿಗ್ಗೆ continue ಮಾಡು. Yes,
On submission, I
Because,
filed a memo that may kindly be taken on it. Inadvertently, because of inadvertence on the part of my colleague, instead of amended writ petition, my lord, unamended writ petition has been filed.
you want to replace it.
Replacer, if it is taken on, seal is there, everything is there, my lord. Because of corona, my lord, there some lapses were there. It was filed a long back.
Memo is taken on record.
Oblige.
Yes, yes.
Number 26, Mantesh Patil.
Just wait.
The seal number, Seal number 17. Seal number 17.
This matter, I got the
Satyam
instructions
Pawan
that
Kumar.
till 1 month, my lord, they will not get the permission because they have even they are not able to, my lords, get the permission itself.
Then
My
counsel for
request,
the respondent.
lords, my request is, my lords, interim order may kindly be passed till the next date of hearing, and I will file the reply to the
In light of the contentions raised and taking note of the observations made in the regular second appeal.
Yes.
Page
Number 100 and
page 9, internal page 9.
internal page
The
9.
order passed in RSA 200281, whereby
Page 262.
the court had clarified that the findings recorded by the courts, by both the courts, would not come in the way of authorities initiating appropriate action if there was any violation or encroachment in the approved layout formed by the competent authority. Subject to further consideration, there would be an interim order of
Stay of the order of the learned single judge.
stay of
The
order of the learned single judge till the next date.
Great.
liberty may be reserved.
Liberty is reserved to the respondent to seek for modification of the said interim order upon filing their statement of objections.
Grateful.
Seal number 26, Mantesh Patil.
Yes, Mallapur.
Lords, annexure D, page number 43, my lords.
But all these orders are of 21.
My lords, kindly see the annexure D, my lords. 19/6/21 ಅಲ್ಲಿ there was an order under 246(8), my lords. Thereafter, they initiated the proceedings before the criminal miscellaneous number 1120/2022. Continuously, my lords, the notice was not served on us because of the reason that there was a wrong address shown in the entire proceedings. Even I have produced the RPD acknowledgement also, my lords, for kind perusal of this honorable court. They mentioned that the taluk is Linksgur. In fact, the village and comes within the Manvi taluk, my lords. Pin code is wrong.
No, no, the inquiry was by whom?
My lords, by enquiry by the taluk panchayat executive officer, my lords.
You are working at?
No, my lords, I am a
President-
ex-president of the
Gram
panchayat. my
Panchayat.
lords.
They were the presidents of Gram Panchayat.
He's saying he's not been notified at all.
Entire proceeding we have not notified.
Not, so far
And,
as far as the report was submitted to the ZP to take action. Till that, thereafter, my lords, the ZP has issued notice to them. They say that notice has not been received. That has to be clarified by the third and fourth respondent. So as we are concerned, we didn't conduct any inquiry. We gave the report under 12(3) months. Since they were presidents, monarchs, ZP rules were applicable, Panchayat Raj rules were applicable to them.
How-
And as far as others, monarchs, KCSR rules ಅಲ್ಲಿ ಇದು ಮಾಡಿದ್ದಾರೆ.
The identical
Everybody,
issue has come up, my lords.
It is
Identical issue has been considered by the division bench of this honorable court. At 246A. Para 12.
There must be inquiry.
House. That is specifically it has been referred. There is no enquiry in the present proceedings. Para 12 ಅಲ್ಲಿ. Para 12 last 5 line. A plain reading of section 246(8) would leave no manner of doubt that to fasten liability or fixing quantum required to be recovered from the member or a president or vice president of panchayat, an inquiry is a must. In the absence of any such inquiry being conducted based only on the reports of Lokayukta, which in turn was based on investigation conducted by the Lokayukta police, no conclusion can be drawn that the petitioners would be liable to pay or deposit the amounts reflected in the said reports. In other words, an independent inquiry will have to be necessarily conducted against the petitioners to fasten or fix the liability on them.
Now here there was no inquiry,
No inquiry.
only on the basis of the Lokayukta report.
Based on only Lokayukta mallards, now they have initiated the proceedings. No inquiry is held. Irrespective of serving notice mallards, even inquiry is also not held. The annexure D. Annexure D mallards, page number 43.
43?
mallards.
Yes.
ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖದನ್ವಯ ತಾವು ಜೇಗರ್ಕಲ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ ಅವಧಿಯಲ್ಲಿ ಸರ್ಕಾರದ ಯೋಜನೆಗಳ ಅನುದಾನವನ್ನು ಸುಳ್ಳು ದಾಖಲಾತಿಗಳ ಸೃಷ್ಟಿ ಸಾರ್ವಜನಿಕರಿಗೆ ಮತ್ತು ಸರ್ಕಾರದ ಬೊಕ್ಕಸಕ್ಕೆ ನಷ್ಟ ಉಂಟು ಮಾಡಿದ್ದಾರೆ ಎಂದು ದಾಖಲಾದ ಪ್ರಕರಣದಲ್ಲಿ ತಮ್ಮನ್ನು ದೋಷಿ ಎಂದು ಲೋಕಾಯುಕ್ತ ವಿಚಾರಣೆಗಳಲ್ಲಿ ನಿರೂಪಿಸಿ ಉಲ್ಲೇಖ 1 ಪ್ರಕಾರ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ 43A ಮತ್ತು 48(4) ಅಡಿ ತಮ್ಮನ್ನು ಸದಸ್ಯತ್ವ ರದ್ದುಪಡಿಸುವಂತೆ ಶಿಫಾರಸು ಮಾಡಲಾಗಿರುತ್ತದೆ. ತಮ್ಮ ಅವಧಿ ಮುಗಿದಿರುವುದರಿಂದ ಇದಕ್ಕೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದಿಲ್ಲ. ಉಲ್ಲೇಖ 2 ತಮ್ಮ ವಿರುದ್ಧ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ ಅಧಿನಿಯಮ 1993 ಪ್ರಕರಣ 246(8) ರಂತೆ ಹಾಗೂ ನಾಗರಿಕ ದಂಡ ಸಂಹಿತೆಯಲ್ಲಿ ಸಿವಿಲ್ ಮತ್ತು ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ಹೂಡಲು ಆದೇಶಿಸಲಾಗಿತ್ತು. ಅದಾದ್ಮೇಲೆ then the amount is now not quantified. ಪ್ರಯುಕ್ತ ತಮ್ಮ ವಿರುದ್ಧ ಕ್ರಿಯಾ ಯೋಜನೆಗಳ ಕಾಮಗಾರಿಗಳ ಒಟ್ಟು ಮೊತ್ತ ಸೋನ್ಸೋ ಸಾಲಿನ ವಿವಿಧ ಯೋಜನೆಗಳ ಕಾಮಗಾರಿಗಳ ಅಂದಾಜು ಮೊತ್ತ 14
No
ಲಕ್ಷ.
inquiry under
No inquiry.
246A. In light of the contention of the petitioner that the recovery and its the quantification and direction for recovery is without being preceded by an inquiry as contemplated under section 246 subclause 8 of the Karnataka Panchayat Raj 1993. And taking note of the order passed in WP 16093 of 2018 relied on by the petitioner, subject to further consideration, there would be stay of
mallards annexure. Order. Stay of mallards order dated 26/9/2024 annexure G and FLW date mallards 6/8/2024 and further proceedings in criminal miscellaneous number 00.
stay of annexure, order at annexure G.
Yeah,
G and G.
Next is G.
Any, where is the stay of?
Next is G is the
next-
application.
Further proceedings in criminal miscellaneous number as.
Mantesh,
Further proceedings, my lords, in the criminal miscellaneous number 1120 of 2022.
there are further proceedings in criminal miscellaneous. Double one,
20.
1119.
ಎರಡು ಪಿಟಿಷನ್ ಇದಾವೆ ಅದು ಇನ್ನೊಂದು 32 ಇದೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್
1119 of 2022
119 of 2022
till the next date.
32 also connected matter 32 mallards is the connected matter there are two criminal
First club ಮಾಡಿ. First club ಮಾಡಿಬಿಟ್ಟು ಆಮೇಲೆ ಕಾಮನ್ ಆರ್ಡರ್.
ಕಾಮನ್ ಆರ್ಡರ್ ಅದರಲ್ಲಿ 1120 1120 of 2022 criminal miscellaneous
Two implications, my lords, two separate.
What are the two numbers?
1120 of 2022 criminal miscellaneous
And
ಇಲ್ಲ ಅಷ್ಟೇ ಸರ್ 1120 of 2022
common order, stay
ಕಾಮನ್ ಎಂಟೈರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
stay of further proceedings in criminal miscellaneous 1120.
20 of 22 ಇಷ್ಟೇ
Number 30. Number 30.
Only the dispensation I1 of 24 is dispensed with the subject to the undertaking that they would produce. Dispensed with under the I1 of 24 is allowed. Petitioners dispense with production of certified copies of annexure B, C, D and F. And IA2 of 2024 is allowed. Petitioners dispense with production of translated copies of annexure A, C, D and F for the present. Yes.
My lord, I pray for short accommodation.
List after Dasra vacation. Yes.
Number
Leader and council. Yes. Next.
number 44. Lakshmikant ji. AG, Vijay Kumar sir, AG sir.
Please, my lords.
Yes.
Could I commence, my lords?
Yes.
Let's appreciate my learned friend for the research that he has painstakingly undertaken, my lords. Although in the process, my lords, probably the preventive detention has been extended by 40 extra days, my lords. I think the commencement commenced on 27/8, my lords, and it's gone on till today. My lords,
It will be extended till we have.
further, I understand that, my lords, I do understand that. My lords, before I meet up with the various contentions that my learned friend has submitted on, my lords, I would commence with the last of the submissions made by him, my lords. This is regarding per incuriam and sub silentio. My lords, per incuriam would be lack of regard to the law itself or binding court decisions, whereas sub silentio would be, my lords, without any reference or mentioning to a point of law. Now, my lords, when we make a submission that the apex court's ruling is per incuriam, that submission is done with great caution, my lords. We never use the term loosely, my lords, unless we are in a position to show what was the ratio of the earlier judgment and how the ratio has not been considered by the subsequent ruling. That would be the basis, my lords. So when a submission is made that Amina Begum's case, the two-judge bench of 2023, and my lords, Jasila Shaji's case of 2024, which is a three-judge bench, these two judgments cannot be taken into consideration since their per incurium to Kudiram's case, my lords, which is a 4-judge bench, and to Pesala's case. Now, this was a specific contention which was urged to say the judgments we are relying on, the petitioner is relying on, should be treated as per incurium. So it becomes very necessary for us to know the ratio in both Kudiram's case, my lords, and in Pesala's case. My lords, in my compilation, if my lords would kindly have my compilation, memo of citation, I myself had produced Kudiram's case, my lords.
Yes.
Now it's page 184 is Kudiram Das versus State of West Bengal. 184. My lords, my learned friend would fall back on this judgment to render support to his submission that subjective satisfaction cannot be subjected to judicial reviewability.
Yes.
My lords, this was a 4-judge bench ruling. The matter was under the Maintenance of Internal Securities Act of 1971, my lords. And there's no doubt, my lords, the matter dealt with a public order and not with a law and order situation. The only contention, my lords, in Kudiram's case was whether the referred to documents, if it is not given, will the preventive detention order be bad in law? And they would hold merely because the referred to documents are not given, it cannot be held that the preventive detention order is bad. This is a ratio in Kudiram's case, my lords. If my lords would kindly notice page 187, the very first paragraph, my lords, 187. First paragraph, my lords may notice that this was under section 3 of the Maintenance of Internal Security Act 1971. We get that in the first paragraph. And paragraph 2, my lords, please notice the date of the detention order, 3rd November 1973. Now, please notice 188, my lords, the 3 instances that had taken place for the preventive detention order. My lords, the detainee, the allegation against him was he was cutting electricity supply to the whole community. We get that at 188, 1, 2, and 3. My lords should get those 3 instances. That was noticed to be a matter which comes under a public order and not a law and order where the entire community is affected. Of these 3, my lords, please notice the 3rd one, which was May 23, 1973. My lords, I pointed out the detention order is 3rd November 1973. The last of the incidents was on May 23, 1973, which is 5 months in terms of the proximity of time from the last date of incident to the order of detention passed against the detainee. Now kindly notice page 189, my lords. What was the ground urged? Non-supply of documents was the main ground of challenge, 189. My lords, A, B, C, D, all pertaining to, my lords, the supply, non-supply of the requisite documents. Thereafter, my lords, the court goes into the issue of subjective satisfaction, whether it can be subject matter of a judicial review. My lords may notice page 194, paragraph 9. It commences by saying, but that does not mean that the subjective satisfaction of the detaining authority is wholly immune from judicial reviewability. The courts have, by judicial decisions, carved out an area, limited though it be, within which the validity of subjective satisfaction can yet be subjected to judicial scrutiny. So, my lords, the ratio is not that a subjective satisfaction cannot be a subject of a judicial reviewability. Very specifically, the court holds it can be subject matter of judicial reviewability. My lords, this is exactly what is followed in Amina's case, as I will point out, my lords. So to hold Amina to be a judgment which has to be treated as either sub silentio or, my lords, in the nature of saying per incurium, that doesn't arise, my lords. Now, please notice thereafter, my lords, the proximity of time the court touched upon at page 199, line about 8 from the top, the proximity of time. My lords should notice there the sentence beginning with, there is a possibility that certain materials on record, my lords got that question, my lords, about line about 8 from the top. There's a possibility that certain materials on record would disclose that the activities of the détenu are of a serious nature having a nexus with the object of the act, namely the prevention of prejudicial act affecting the maintenance of supplies and services essential to the community, and having proximity with the time when the subjective satisfaction forming the basis of the detention order has to be arrived at. So, my lords, the court would also recognize the proximity of time between the last act to the order of passing a detention order. And, my lords, the portion after that is what I had already read when I made my submission, my lords, where it says, where the liberty of a subject is involved, duty of the court. I had read that on the last occasion. I will not repeat reading that. And thereafter, my lords, please notice in that case, the clear subjective satisfaction on the basis of an activity affecting public order. We get that at page 201, my lords. My lords, it's at the last sentence above paragraph 17, last sentence of 16th paragraph. There was therefore no material before the district court other than the 3 incidents set out in the grounds of detention, which went into the formation of the subjective satisfaction of the district magistrate, and which ought therefore to have been communicated to the petitioner. Ground C must accordingly be rejected, because all the documents pertaining to the 3 incidents had been given to the détenu. Now, my lords, so this is what the entire case of Khudiram Das was, my lords. So the ratio isn't as what was sought to be portrayed, and it isn't something, my lords, which has not been followed in Amina's case, my lords. Now, the second judgment, they said, my lords, was in the case of Pesala Nukaraju, my lords. Pesala Nukaraju, a 3-judge bench, The order is dated 16th August 2023. My lords, this was produced as Annexure R9, my lords. Annexure R9. I think it is in their first of their volumes, my lords, along with the objections which they produced, the judgments. Page 59 in that, my lords. My lord, gets page 59. Now, this is an order, my lords, dated 16th August 2023. My lords, in Cherukuri Mani's case, which was of 2015, it had been held that the preventive detention can be only for 3 months, and thereafter it has to be periodically extended, my lords. This is a 2015 judgment. That judgment is overruled in this particular judgment, my lords. They said it is not 3 months. A preventive detention can extend to 1 year. My lords had a doubt while reading it, my lords. Is it only 3 months that it can be done, or can it be for 1 year? So, my lords, it could be for 1 year. The 3 months period is only so far as subdelegation is concerned. It has nothing to do with the detention order. That point has been clarified in this judgment. So, they overrule, my lords, the judgment in Cherukuri Mani of 2015. This was the first aspect of this judgment. And the second aspect of this judgment was an act of bootlegging would come under the definition of a public order. Act of bootlegging will come under the definition of a public order. These are the only 2 aspects, my lords, that were considered in this judgment. Now, my lords, please now notice Amina's case, my lords, whether Amina's case in any way has altered what has been stated in either of the 2 judgments. In fact, my lords, they would follow it. My lords, Amina's case is the very first case in my compilation, my lords. Very first case in my compilation. Amina Begum versus State of Telangana, 2023 9 SCC 587. My lords, in this judgment, they speak on subjective satisfaction, which can be under judicial review. That's the first aspect. Now, that does not go against either of the 2 judgments, my lords, earlier. That's the first aspect. Second, my lords, in Amina's, they say, when can the power of preventive detention be exercised? Again, my lords, would not go against the 2 decisions. My lords, Amina deals with what's the difference between a security of a state, public order, and law and order. Amina would say, how should this 1 year period of preventive detention be looked into? And lastly, my lords, they would say there should be a balance between preventive detention and the golden triangle, which is 14, 19, and 21 of the Constitution. Not one aspect, my lords, would come under the term of per incurium or sub silentio. Please notice, my lords, in Amina's, in fact, at page 14, the judgments relied on, my lords. They point out which is overruled and which they rely on. My lords, the second judgment in page 14, which is referred, 2023 14 SCC 641. My lords, this is Pesala Nukaraju. Please notice this along with 11, my lords. 11 is Chirumukhi Mani versus State of Chirumukhi Ravi versus Mani versus State of AP, which is at serial number 11. So, my lords, in serial number 2, they have overruled serial number 11, which is followed in Amina's case. My lords may also notice serial number 22, my lords, which is Khudiram Das versus State of West Bengal, which is at page 15, serial number 22. My lords, Khudiram Das has been referred to at paragraph 16 of this judgment. Page 21, the reference to Khudiram Das was the State of West Bengal. And my lords, they would extract what is there in Khudiram Das and follow what is there therein. Entire paragraph 16, my lords, it goes from ink page 21 to 24. And Nukaraju's case we get, my lords, at paragraph 80. My lords, it's at page 44. My lords, you get that?
Yes.
So, my lords, the submission to say this judgment would be either per incurium or sub silentio is absolutely without a basis, my lords. The other judgment they said is also per incurium and sub silentio. That's the decision of 2024, my lords.
Lords can permission.
It
My
is
lord,
just. Can I just finish on my reply?
Let him finish, we'll come back, Vijay. Let him finish, we'll come
No,
back.
my lords, I want to assist my learned friend also. The reason why I said it is per incurium is because of para 52, my lords. Para 52 in that very judgment, Amina judgment. I'm sorry, I'm sorry.
We'll come back, let him.
Please, my lords, the other judgment of 2024 in Jasila Shaji versus Union of India. Could I just request learned colleague there to pass on that judgment, my lords? That's of 2024, which again they said is per incurium. 3-judge bench, my lords. They went on the issue of relied upon document has to be given to the detinue, failing which the detention order is bad. My lord should notice it, paragraph 5, Amina Begum is quoted, paragraph 5, my lords. And they follow it up at paragraph 6, relied upon documents. My lords, the consideration of it, we get at paragraph 17. My lords should notice 2 contentions there. First one as to whether the non-supply of statements of so-and-so has affected the right of the detinue to make an effective representation under Article 22 5 of the Constitution of India as to whether non-receipt of the representation and the delay in deciding the representation by the detaining authority and the central government would also affect the right of the detinue under Article 22(5) of the Constitution. Now, this, my lords should notice at A, they have a complete discussion, and at paragraph 25, my lords, in keeping with Khudiram's case, paragraph 25, bottom, my lords, there can be no doubt that it is not necessary to furnish copies of each and every document to which a casual or passing reference may be made in the narration of facts and which are not relied upon by the detaining authority in making the order of detention. Failure to furnish copies of such document or documents as are relied on by the detaining authority, which would deprive the detainee to make an effective representation, would certainly amount to violation of the fundamental right guaranteed under Article 22, Subarticle 5 of the Constitution of India. Now, my lords may notice paragraph 33, my lords. It is thus a settled position that though it may not be necessary to furnish copies of each and every document to which a casual or passing reference has been made, it's imperative that such document which has been relied on by the detaining authority and which affects the right of the detainee to make an effective representation under our Constitution has to be supplied to the detainee. Thereafter, my lords, paragraph 44, they say non-supply of a relied upon document, my lords, it vitiates the detention order. Paragraph 44. In that view of the matter, we have come to a considered conclusion that non-supply of the statements of so-and-so has affected the right of the detainee to make an effective representation under Article 22, Subarticle 5, and as such, the detention is vitiated on that ground. Then they go into the second aspect, my lords, on representation not being considered within a reasonable time. There was a 9 months delay, my lords, where it was not considered. I will not have to trouble my lords on this.
No, so if they've relied upon that in their order.
Yes.
And that's not furnished, then it is fatal.
Yes, my lords, it's fatal. The detention order has to go. My lords, in my case, the bail orders have not been made available to me, though one of the grounds is I have breached the conditions of the bail. That's ground number 6, which I have taken, my lords, specifically.
But their contention was that these orders are orders in which you are also a participant. At your instance, orders were got. So then they rely on the division bench judgment to state that it may not be fatal. What do you want to have?
No, my lords, once they rely upon a ground, irrespective of whether we were a part of that proceeding or not, the reason for it to become part of the documents to be given to us at that point of time is to enable us to do an effective representation. So throughout, my lords, in various aspects, FIR I may know about. They may want to rely on some part of the charge sheet I may know about. Despite that, my lords, when they make the grounds here, copies of it have to mandatorily be given to me so as to enable me to make a representation. This is how it stands, my lords.
But some observation is made in the order they rely on by the division bench of this court at the first in the writ appeal.
Yes, my lords.
In the writ petition order.
Yes.
55 of 2024,
Yes,
last of the orders of the coordinate bench.
page 241, my lords.
There they rely on some observation made there.
My lords, there they say they were not made the basis on which the detention order is founded. My lords, could I read that portion, my lords?
Page,
In the same page 241, my lords, 55 of 2024. My lords, C may be noticed, my lords, in that.
Yes.
I think this is the portion that they try to refer on to say that it need not have to be given. But please notice what is observed there in my lords. The next submission of the petitioner, the respondent failed to furnish the detainee the copies of the bail orders secured by the detainee, and that has prejudiced his case in structuring the defense at this stage of making the detention order. Again, does not merit acceptance. Detention order dated so and so makes a reference to several bail orders, giving full particulars of the case, such as court which granted the bail, the date of the bail orders, and the cases in which they are made. The detainee has not and could not dispute these orders in as much as it is he who had secured them. Learned SPP is more than justified in his vehement submission that all these bail orders are only referred to, that may be noticed, my lords. They are not relied upon, only referred to in the detention orders as a part of chronology of events. They are not made the basis on which the detention order is founded. Whereas in ours, ground number 6 is specifically, my lords, on breach of the bail conditions without even making the bail orders as part of the documents given to me.
So you are saying it must be strictly construed and,
Yes, my lords.
and the proceedings must be treated as if it's a fresh proceedings without reference to other proceedings.
Absolutely, my lords, absolutely. Because this is preventive detention, you're treating it as a ground to detain me. I have every right to get a document from you so that I can make an effective representation.
No, you're saying that this consideration of reply to the order will
Yes.
be made when he's already in preventive detention.
Absolutely, yes, my lords.
And hence access to anything which otherwise he would have had when he was free will not be there.
Yes, my lords. That's absolutely right, my lords. That's the whole object of saying within a period of 5 days, you should provide the grounds on which you're detaining him. The time limit is also provided there. You may pass a preventive detention order. You have to follow it within 5 days on the grounds of detention.
Access to representation is not there, or it's discretionary at the advisory at that stage?
No, my lords, it's a mandate. Initially, my lords, once they give a ground of detention to me, I would get a right of giving a representation. Now, if I don't exercise that right, then there's nothing for them to consider, my lords. I continue to be in preventive detention. But if I exercise that right and give them a representation, they're bound to consider it. Now, if it is going to be an authority, my lords, on a delegated power, and at that point I give him, he considers it. If it is going to be on the basis of an order approved by the state government, they would consider it, my lords. And
No,
if I have given...
No, I'm saying access to legal representation in this process is discretionary or...
No, my lords, before the advisory board? My lords is asking, is it before the advisory board or?
No, the consideration of the representation is by the authority even before the advisory board. So
my lords, yes,
at that stage of consideration of reply.
Yes, my lords.
Right of legal representation is...
No, not at all, my lords. We don't have a right of legal representation throughout. The first time it comes is only in a habeas corpus, my lords. Till that point of time, he can't have legal assistance either before the concerned detaining authority or before the advisory board.
Yes.
My lords, if I've answered that point, my lords, which was taken up last as sub-silent show, my lords, and per incurium. Now, if my lords would kindly notice my synopsis, which I gave with the grounds that I had taken, I will point out which is met, which is not met. My synopsis.
Yes.
My lords, at page 2 of that synopsis, the points for consideration, my lords would notice.
Yes.
Now, my lords, kindly notice the first point, my lords, which we have taken, stale ground, snapping of live link, no proximity between the last prejudicial activity registered to the date of detention order. My lords, as I had pointed out, 2021 was the last case against me, and 2024 May was the detention order.
The counter argument to this point, they relied on some judgment to state that proximity may also have to be looked into from the context of previous pattern of behavior.
I get that, my lords. I get that. Now, as a counter to this, the first instance when it was pointed out by the court, they got back to Dawood Ibrahim, my lords. I don't see how Dawood Ibrahim's case can be equated to this particular ground. Dawood Ibrahim, my lords, they said 1982 fled the country. Actually, it was 1986 he fled the country, my lords. There was no order of any preventive detention against him. Then the Bombay Act took place in 1993. Now he is considered to be number 2 in the top 10 most wanted fugitives in the world, my lords. To get his example, to say we should look at it from this point of view also. Probably if we had preventively detained him for how long? 1 year. What would you have done after that? Nothing. So lapse on your part, you can't try to make use of it to say this particular ground, this would be my reply. That first part of it will have to go, my lords. And the second aspect which they pointed out is, my lords, they said proceedings under 107. In one of the cases, they tried to rely, my lords, CRPC 107 proceedings close to the date of detention order. My lords, I had pointed out that the act itself, section 2G, which defines Gunda, shows which are the offenses for which consideration can be there. Only IPC offenses. My lords, notice this on the previous occasion, the definition 2G, my lords. When you say a person is Gunda, Gunda means a person who either by himself or a member of or leader of a gang habitually commits or attempts to commit or abets the commission of offenses punishable under chapters 8, 15, 16, 17, and 22 of the Indian Penal Code. CRPC is never included, my lords, for you to declare a person as a Gunda.
No, but they're trying to, their argument appears to be that he being subjected to 107 proceedings, one would indicate that he has a connection with Kalaburagi. 2, it is some kind of a pattern which they apprehend is a continuous pattern of behavior.
My lords, 107, my lords saw in the CRPC, 107 is merely a security for good behavior. Now, if I have committed an act, a case should have been registered against me.
But can you?
24, no case registered against me.
Yes. Now in the second part, what do you say regarding their contention? This 107 proceedings, even if does not come within the chapter of offenses under 2G, may still establish some link of proximity. What do you say regarding that?
My lords, for link of proximity, they will have to be an offense, my lords. 107 is not an offense. 107 is merely a procedure of taking a bond for good conduct. So from 2021 to 2024, if there's no offense, then, my lords, the ground becomes stale.
What do you say regarding that order that they relied on, which said that if there's a pattern?
I will point that out, my lords. If my lords would kindly have volume 3, serial number 1, which they relied on, 2005, 3 SEC, page 666, collector. First one.
Volume, which one?
Volume 3, my lords. I think they've given it as volume 3. They've given
Yes.
3 judgments in volume 3, my lords. My lords, if my lords would notice this first judgment 2005 3 SEC, please notice the very head note, my lords, in this. Preventive detention, evaluation of grounds of detention, stale grounds, if the ground forms a chain of incidents which are proximate to each other, and last of the incident is proximate to the date of the proposed detention, then held, even if the first few incidents are not proximate to the date of detention, detention order cannot be set aside on ground of being stale. So the last incident and the detention order, my lords, that should be in close proximity. So in fact, this judgment would be in my favor rather than in favor of the detaining authority, my lords. Now, please notice the other judgment they relied is a third judgment therein, my lords. My lords, the third judgment, please notice, my lords, in what context that paragraph, it's a very small judgment. My lords, it contains about 11 paragraphs, my lords. Paragraph 5 and 6 may be noticed, my lords. That is where my lords felt their pattern. My lords, can I read paragraph 5, which is at page 369, my lords?
Yes.
The High Court did not find any substance and noted that several offences were registered from 2005 till a few dates before the order of detention. May I just pause here, my lords? This is where they say, even just before the preventive detention orders, even a few days before, there were cases registered. Thereafter, they deal with 107 after that, my lords. He gives a bond, he breaches the bond repeatedly, they go into the issue of bond. So this aspect of bond was read to point out that it could be a link, but no, the very first line in paragraph 5 says there were cases registered just earlier to the detention order. My lords, I hope I'm clear on that, my lords.
Yes.
So these are the 2 judgments, my lords, which was relied against my ground of saying the grounds are stale, there's snapping of live links, there's no proximity between the last prejudicial activity to the date of detention order. So, my lords, my first ground, that is in the points of consideration, my lords, itself would suffice to set aside the detention order.
Para 10 of the same judgment, just have a look.
Yes, ma'am, I will. Public order, my lords, I think the distinction between
No, no.
public order.
Para 10, last page 372.
My lords, is it coming to the question of live link, my lords?
Last.
Yes, yes,
That was
yes.
subparent was.
Yes, my
Yes,
lords.
sir.
Coming to the question of live link, it is to be noted that the provisions empowering detention relates to an habitual activity of the proposed detinue. Therefore, there has to be instances which may not be immediate proximity, but may indicate that pattern. In the instant case, incident cannot be said to be remote past to warrant conclusion of the absence of live link. My lords, kindly notice this with what we just read as paragraph 5, first line. This is not in reference to a bond, my lords. This is in reference to an offense. So live link continues there. And that's the case, my lords. 3 bonds he took, he breached all the 3 bonds. So when he breached it, obviously offenses will be registered. That's the relevance of paragraph 5. Just before the detention orders, there have been cases against him. My lords, I hope I'm clear on this, my lords. Paragraph 5 ಅಲ್ಲಿ first sentence ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅದನ್ನ. High Court did not find any substance and noted several offenses were registered.
Now you're saying under para 5,
Yes, my lords.
under para 5,
Yes, my lords.
there were offenses registered.
Yes, my lords. Offenses were registered. My lords, he had given bonds, my lords. He breaches the bond. As soon as you breach the bond, your good behavior, bond for good behavior goes, there would be registration of crime. That is what we get as the first line in paragraph 5. They say registered from 2005 till a few days before the order of detention.
Now that may be even other than 107. We are not sure, but
What,
it may be-
107 is just a bond, my lords. 107 is
No, I'm
not an
saying-
offense.
correct. No, I'm saying under the first line at para 5,
Yes, my
it
lords.
could be referring, it could also be referring to actual offenses registered.
It refers to the actual offenses, my lords, not to
Yes.
the bond, because you use the word offense, which
Yes.
is registered.
Yes.
So, my lords, as I mentioned, 107 is not an offense, my lords. 107 is just giving a bond for good behavior, nothing more than that. So, this relates to offenses registered just before the. So, my lords, the judgments which they rely on will not dilute this ground that I've taken, my lords, on stale grounds, snapping of live links or no proximity. So, that
yeah.
first ground, my lords,
So you are saying that mere 107 proceedings cannot amount to extending the proximity.
no, it doesn't, my lords. In my respectful submission, it doesn't.
Yes.
My lords, same in the points for consideration, if my lords should now see.
Yes.
my lords, in the points for consideration, my lords, if my lords would now notice, ground 2 and 6 have to be read together, my lords. It's one and the same. Non-disclosure, my lords would get that.
Yes.
Ground 2, non-disclosure with reference to each of the grounds for detention, which are all the documents relied on and which are all the documents referred to in the narration of facts. My lords, I had relied on coordinate benches, my lords, the guidelines that was laid there that you have to give it. But now I'm supported by the Supreme Court ruling of 2024, which I just read to my lords, Jasila Shaji versus Union of India, 2024. So any document which you are relying on, now if you say I've breached my bail conditions, then you should have made available the bail orders. So this should be read along with ground 6, my lords, in the same one. The ground of detention discloses alleged breach of bail condition, ground number 6 at page 40. The breach of bail condition is at best, cancellation of bail can be sought, not an order of preventive detention. So this two grounds, my lords, it has not been addressed upon. They went into the aspect of certain illegible documents which are not relevant. For that, I should not be given the benefit. Fair enough, my lords. But these two grounds of saying relied upon documents not given to me.
But in so far as the contention that there is a procedure prescribed or an mechanism available under the law itself.
Yes, my lords.
Need not necessarily tie the hands of the authority to take action under preventive detention. They relied on some authority to state that acquittal, discharge, suppose based on failure to establish standard beyond reasonable doubt. That by itself may not necessarily tie the hands for preventive detention.
I do agree with that, my lords. Now, I do agree the fact that it doesn't tie their hands, but how the interpretations have been insofar as bail and violation of condition, consistently Supreme Court has said, if you are going to say it is because of conditions in the bail being violated, you should look at seeking cancellation. Don't use it as a ground to say, now I'll put you under preventive detention. You don't even make an attempt to cancel it. How would you go under preventive detention? This is how Supreme Court has interpreted it, my lords. And my lords, in fact, my lords, those judgments also, in my list of judgments, I have pointed that out, my lords. In my list of judgments, my lords, please notice Roman number 5 only for breach of bail condition, only cancellation of bail, not preventive detention. The latest two rulings, Amina Begum, paragraph 54, and this now Ninawat Bujji of 2024, latest two judgments, which speaks about it. I put the paragraphs there, 54 and 41.
Yes, yes, yes.
So, my lords, ground 2 and 6 gets covered there, my lords, which is in addition to ground 1 of stale grounds. Now,
Yes.
ground 3, my lords, extraneous
Audio hoಯ್ತು
my
ತಮ್ಮ.
lords.
Yes, there was a slight interruption. We couldn't hear you.
That becomes part of this detention order. That can't be done because it's extraneous consideration.
We couldn't hear you for a minute.
In that synopsis first page, I've given total number of 12 cases acquittal.
Yes.
Acquittal find place in the detention order consideration.
No, we couldn't get you. There's some audio interruption.
Oh, I'm sorry. I'm sorry, my lords. Could I repeat myself on ground 3, my lords?
Yes, yes.
My lords, ground 3, we said My lords,
Yes,
am I audible now?
yes, act of God.
I think we are arguing the matter too much in detail.
Yes, ground 3, yes.
Considerations can't be part of the detention order. Out of 25 cases, in 12 cases, I was acquitted. In Amina Begum's case, my lords.
Yes,
My lords, when I mentioned about extraneous consideration, in that list of judgments, my lords, Roman number 3, I have pointed out the 2 judgments, my lords. Again, Amina Begum and Bujji's case, the paragraph numbers, my lords. I have mentioned that as Roman number 3.
yes,
In Amina Begum, it's paragraphs 52 to 54. In Bujji's case, it's 35 to 40 and 43.
yes.
It's on the point, my lords, you can't have extraneous considerations. So, my lords, ground 3, in my respectful submission, my lords, again, there was no great reply given on this particular contention of mine.
Yes,
My lords, ground 4, the activities do not come under the category of public order, but only law and order. Because all that has been stated against me are certain offenses against individuals. So it is not against the community as a large. My lords should remember the 3 circles, my lords. Right in the center, we have security of the state. Around it, we have public order. Around that, we have law and order. These are all activities that pertain to law and order, for which you can't have a preventive detention.
yes,
My lords, the 5th ground, my lords, there's no period of detention in the detention order. My lords, I will really not press it because I did explain that in number of cases it is the same. Supreme Court in one of the cases recognized it also. Even in the initial, if you don't have it, it's okay. So I will not really be looking at ground 5, my lords. Ground 7 again goes with ground 2 and 6, my lords. It's the same thing. Ground 7, bail orders, application are not part of the documents.
yes,
My lords, the next one, illegible copies, though we have given all the page numbers, they say it is not of great relevance. We leave it, my lords. I will not even go on illegible copies. My lords may notice ground 9, delay in consideration of representation. About a 19 days delay. I relied on 2 decisions, one of our court, coordinate bench, His Lordship Justice Oak authored the judgment, in which, my lords, there was a 10 days delay and the court sets aside the preventive detention. My lords should get that in my list of citations.
correct.
The last 2, serial number 10 and 11.
Correct, but I think they relied on some other judgment to the contrary, isn't it?
My lords, all this will have to be seen in terms of what is the extent of delay. Now, in our case, my lords, we have said 19 days delay in considering the petitioner's representation. 19 days.
Yes,
And the judgments I relied on, 10 days delay, my lords, in the first of it. I'm sorry, second, that's at serial number 11. It was a 10 days delay. And serial number 10 was the guidelines, my lords. Any number of representations given, they're bound to consider and give replies. So, my lords, these were my grounds, my lords, in my respectful submission, for which the state has not been able to effectively counter on these grounds. Now, please notice, my lords, per contra, what is it that they brought to the notice of the court is, my lords? First is, my lords, they tried to say there's no difference between public order and law and order. This was the first contention, my lords. Now, my lords, on the basis of various judgments which clearly distinguishes public order from law and order. And every now and then that same example is given, my lords. When two drunkards fight, it could be a law and order. But if two drunkards fight based on their community and create an atmosphere of hatred for the communities in concern, that is public order. Security of a state, obviously, my lords, act of terrorism and all this maintenance of internal security act, those are all on a different footing. So there definitely is a clear distinction between law and order and public order. And preventive detention can only be done if it concerns public order, not law and order. So this is the first contention where they try to say that there's no difference. I beg to differ, my lords. There's a marked difference between the two. Second, my lords, was on subjective satisfaction cannot be subjected to judicial review. My lords, I will not, other than showing Amina Begum, which follows Khudiram, I will not have to touch anything further on that, my lords. It is subject to judicial review, subjective satisfaction. My lords, and the third contention, my lords, they said role of advisory board. My lords, in my respectful submission, so far as advisory board is concerned, section 11(4) speaks on confidentiality, my lords. If my lords would kindly notice, section 11, subsection 4 of the Act, the proceedings before the advisory board are to be confidential, my lords. Only the opinion is what can be seen. Rest of it is in confidence. Now, what has been produced before this honorable court and copies given to us are these confidential reports, my lords.
No, I think we gave it back, so we'll only look into the opinion, so be it. You're
Because
saying
since since we got a copy of it, my lords, in fact, I went through that entire, actually, my lords, we are not supposed to get copies of it at all. It cannot be given.
No, so we look only into the opinion is what you're saying.
Reports are never produced before the court. Now, in our case, my lords, it has been produced and a copy given to us. I was able to point out, my lords, in this report itself, the grounds that we have urged, my lords, none of it is there in it. Whether staleness of the grounds, whether all the documents have been given, none of it is there in it. And there before an advisory board, my lords, there's no legal assistance for it to be put forth.
Yes.
And my lords also recollects, my lords, in that Bujji's case, the role of the advisory board has been touched upon, my lords. My lords, page 151 of my compilation, kindly notice, my lords. Paragraph 49. Relevant is 178, my lords. How the Supreme Court notices about advisory board, my lords.
Yes.
My lords, what would be relevant is paragraph 55 to 60, my lords. Page 180 and 181. In fact, till 62.
Yes.
Lords, if the advisory board looks into every, so we get that in paragraph 59, my lords, they say, preventive detention being a draconian measure, any order of preventive detention as a result of capricious or routine exercise of power must be nipped in in this judgment.
Yes.
Which is at page 86. My lords, in fact, my lords, I'll be able to show what it is to be a part of the advisory board and thereafter view it at the time of judicial review, my lords. My lords, if page, my lords, same in the judgments, if page 70 is noticed, my lords, it's very different, my lords, when it is in the advisory board, it's very different when it is being considered for a judicial review. Page 70, my lords would notice that order, my lords, which is passed.
Yes.
And it's passed by the chairperson, my lords, but on the judicial side. Now, please notice, my lords, on the judicial side, how it is viewed. Page 86 may be noticed, my lords, how it is viewed on the judicial side. Similar as in the case of proximate link, which is my first ground here. Please notice page 86, paragraph 14, my lords.
Yes.
Whole paragraph, 68 days, my lords, between the last case and the detention order. My lords would get that at page 87, line about 8 from the top. The last case and the detention order, 68 calendar days. Now, in my case, my lords, 4 years. But still, the advisory board felt that you could proceed further. But when you're dealing with it as an advisory board, it would be very different than dealing with it when there's a judicial review, my lords.
Yes, we look
My
into
lords.
it.
Yes, my lords. My lords, the next aspect was, my lords, illegible documents. I will not touch upon it, my lords, because I'm not going to be pressing on those documents. And last one which was pointed out was section 6A, severability, my lords. Now, normally, my lords, when we say severability, if a person is going to be detained for more than one act offense, now he may be a bootlegger, he may also be an gunda. Now, you see for bootlegger whether there are sufficient grounds to detain him. And if it is found they aren't, we see for gunda, are there sufficient grounds to detain him? And if it is found it is there, then the preventive detention can be held good. But for one aspect of it, for gunda, you only see the reasons. You can't say because of one reason, I will sustain that ground. That is not what 6A is about, my lords. 6A is about severability of grounds, not reasons. So in our case, my lords, when they call me a gunda, they give several reasons. They can't say this reason is enough, the rest of it need not be looked into. No.
Yes.
My lords, I don't think I'll detain the bench any longer, my lords. This was their contention and these were my grounds, my lords. This is a reply.
Now we reserve liberty to both of you to file further synopsis within 3 to 4 days.
Please. My lords, I'll only rely on this synopsis and my citations. That's all, my lords. I don't have anything more to add to this, my lords.
Yes.
Lords, beg for my lord's forgiveness and my learned friend too. But the para number 59 was what I was placing reliance upon to show that the judgment in Kudiram's Bose was not properly considered in Amina Begum's case because the conclusion in para 52 is different from what the ratio is laid in that particular case. That is all that I wish to point out. I thought I could help my friend also to assist the court in that regard. Not to interrupt with him at all.
No. I didn't take it as an interruption at all.
My learned friend was my senior in my senior's office, my lords. If he was 5 years elder, I would have been his junior today, even today.
It's a pleasure, my lords, opposing Vijay in any matter.
Words reserved for orders. Both sides are at liberty to file synopsis if they so feel within 3 days.
Much obliged.
Deeply obliged, my lords.
Till now 42, Vishal Pratap Singh.
This we'll hear after Dasra vacation, we'll hear.
I'm grateful.
Huh?
I'm grateful. My
Whatever-
submissions are all complete, my lord.
Correct, no, that's there. Your only oral submissions are complete.
Yes, my lord.
Written submissions I require.
I'll file the written submissions.
Now, we'll fix a date after Dasra vacation.
Please, ma'am.
If both of you can file written submissions, it would help.
We will do it.
Huh?
We will do it.
List the matter for further hearing after Dasra vacation. If you file written,
Please.
so that in vacation you can do some work. Otherwise, I won't press the state normally, but if you could file, so the next time we can have briefly, because most of it is covered, I think.
90% is.
90%. So what you do, you file in written, then we'll fix a date.
Please.
After Dasra vacation. By then, if possible, by reopening day, file one brief written submission.
Please.
My written submissions will be confined only to the point of law on juvenility or because merit.
Both.
On
Both.
merit as well as this.
Yes, both.
I will do that.
43, Ganesh Chubha.
I'm grateful, my lord.
Yes.
My lord, this is a
One
matter
also
where.
we'll have it after Dasra vacation.
Please.
Here you have to make some submissions, isn't it?
Please.
In this one.
My lords, I had to only make that note, written note on the point of, sir. My lords wanted me to see on what grounds your lordships may say that 226 is maintainable. In fact, my friend has prepared all this. My lords will come to it, internal page 4. In internal page 5, we have found out what we can fathom about. These are few grounds on which the 226 petition can directly be maintained without relegating the parties to an appeal or other provision. One is, of course, violation of any fundamental or legal right, which is the text of Article 226 also. Principles of natural justice is one which is an accepted ground. D, E and F, my lords, are the ones where, especially D, when the appellate authority is not available or is not taking up the matter within a reasonable period of time. That's the time when somebody can approach first in an appellate forum and within a reasonable time, which your lordships may decide what would be reasonable. If the authority is not taking up the matter for whatever reasons that, then my lords may say that 226 is the only remedy which can be entertained then. It's the right of a party is affected by that.
One day we'll have it after vacation. The additional written submissions filed on behalf of the petitioners is taken on record. List for further hearing after the
Submissions. Submitting some citations.
Putting. Judgments relied on by the additional state public prosecutor along with memo is also taken note of. One date, a brief hearing will have.
Please.
After this.
Seat number 6. Brother Kalyani.
We could manage another 10,000 years, sir. 15,000, total 15,000 is.
It comes to 26,700.
Huh?
One third, my lord, you submit, one third comes to 26,700 out of 8.
Having some financial problem, your lord. This is genuine case, your lordship. That is what I am submitting.
ಕೊಡಿ ಕೊಡಂತ.
Yes.
ಎಲ್ಲಿದ ನಿಮ್ಮ ಕ್ಲೈಂಟ್?
ಎಷ್ಟು ಅವ್ರಿ?
ಅವನ ಹತ್ರ ಕೊಡಿಸಿ, ನೀವೇ ಕೊಡ್ತೀರಿ.
Because serious allegations of adultery has been made and that has been proved, your lordship.
It's a matter of.
By
that's
way
a
of
matter
fact,
proof.
it has been proved by the before the trial court.
We are not touching.
This is what your, what
It's
his
not
mentality,
justice
We are not touching.
ಅವ್ರು ಏನ್
to
ಹೇಳ್ತಾ ಇದ್ದಾರೆ?
defame the persons.
ಅಷ್ಟೇ.
ಅವರು ನಮಗ್
ಅದೆಲ್ಲ
ಪ್ರಶ್ನೆ
medical
No,
decide
we are not
ಮಾಡಿ.
entering into that. That's a
Uh-huh.
different matter.
Okay,
That is correct, your lordship. What he is asking,
Huh?
what ಅವ್ರು ನಮಗ್ ಕೇಳ್ತಾ ಇರೋದು,
We leave
Sir,
it at that. We leave it at that.
ಕೊಡಪ್ಪ ಕೊಡು.
ಅನೈತಿಕವಾಗಿ ನಡೆದವ್ರಿಗೆ ನೈತಿಕವಾಗಿ ನನಗೆ ದುಡ್ಡು ಕೊಡ್ಲಿಕ್ಕೆ ಮನಸ್ಸರ್ ಹೆಂಗಾಗ್ತದೆ ಸರ್, ಸ್ವಲ್ಪ ನೋಡ್ಕೊಳ್ಳಿ, ನಾ ನ್ಯಾಯ ಒದಗಿಸ್ಕೊಡಿ ಅಂತ he is asking me, sir. That is what he is.
That's a matter to be decided.
That is
on-
what he is.
Matter to be decided on.
This genuine case, your lordship, on fact it has been.
There is no touch ಮಾಡ್ತಾ ಇಲ್ಲ.
Yes, your.
Disseminate has to be paid ಅಲ್ಲ, as ordered by the court.
Yes.
Court order ಮಾಡೋದು ಕೊಡೋದು
ಅಲ್ಲ
ಅಷ್ಟೇ.
ಕೊಡ್ತಾ ಇದ್ದೀನಿ. I also filed affidavit, your lordship. That is what I am saying, your
It's
lordship.
not,
What
it
we are
is,
saying, suppose we were to dismiss, we were to uphold their contention in the end. Still maintenance.
No, no, we are ready, your lordship. We are
Okay.
not said we are not paying.
Correct.
Time is required. That is what I am saying.
my lord,
Not
it's
is then
after 1
that is-
year, 10,000. Even honorable court has suggested them to pay at least one third, means 26,700. He has paid only 10,000 after 1 year. After the order, madam.
ಇವತ್ತು ಎಷ್ಟು 15,000 ಕೊಟ್ಟಿದ್ದಾರಾ?
15 ಕೊಡಿ.
ಎಷ್ಟು ಕೊಟ್ರಿ?
15. 15,000.
Appellant and respondent present, the respective counsels present. Next para. Counsel for the respondent has filed an affidavit with regard to the payment of arrears of maintenance ordered by the court. In fact, in para 5 of the affidavit, he has undertaken to pay the arrears of maintenance within a time stipulated. Reads as under. Next para. It is submitted that today the respondent has paid rupees 15,000 towards arrears of maintenance, and it is a partial payment of arrears of maintenance. As he undertakes to pay the arrears of maintenance within 2 months, the said undertaking shall have to be adhered without committing any lapse or default, without committing any default. Fine. The affidavit of the respondent is taken on record. The appellant, ಇದೇನಮ್ಮ ದುಡ್ಡಿದೆ ಅದು?
ಎಣಿಸ್ಕೊಂಡ್ರಿ?
Appellant states that she has received rupees 15,000 from the respondent. Partial payment of arrears. List for, yes, list final hearing.
Yes, yes.
List for, list and final hearing list.
Any specific date, my lord?
Huh?
Any specific date for?
The date could. 30/10.
Yes, much of.
Admissions time. Sorry, ma'am.
Serial number 40, your lordship.
45,
All,
45, my lords have heard it.
Serial number 55 matter, 230 matter. Education matter में लॉर्ड्स. Senior counsel Madhusudan Nayak.
After vacation, after.
Serial number 40, your lordship.
Huh?
Then sir, about to be announced if it is stalled till reopening, my lord. Otherwise again, we become infractions and we need to challenge it.
Let us see.
40,
The results are ordered to be stayed till reopening. If the matter could be taken if we really. The exams which are held
No,
during September.
We'll only observe that court will mold appropriate relief.
It's already started.
So let us see, It requires some hearing and adjudication at some point. Now in some other matter, with interim order, they completed one whole year. So then reversing will be completely difficult. Let us,
45.
huh?
55.
September, they have undertaken some exams. That- Now the results will be announced. Therefore, if they are stayed minutes, then it will be.
No, now the challenge is to the evaluation process, isn't it?
Yes.
So if, since we have observed that the court will mold relief, we'll
Appropriate.
see what will happen finally.
That's-
Or 55,
Yes,
Serial number
55,
40
my lord, it will be
40
taken as
your lord.
21st, my lord.
Serial number 40 or first appeal.
21st.
date should be given by the court of appeal.
Serial number fresh material, serial number 40, first appeal.
Ah.
The 15th October is given date for FDP appearing, your lordship. Suit for partition and separate possession. First appeal, your lordship. Fresh matter.
Third learned,
Date ಹಾಕಿದ್ರೆ
number
report of
43rd on the proposal to the appellant,
ಬರ್ಯಾಕತ್ತಾರ.
by number 1 of 24. Next, put a file
ಎಲ್ಲಾರು ನಮ್ ಪ್ಲೇಸ್ ಕೊಡಂಗಿಲ್ಲ ಅದಕ್ಕೆ ಮೈಕ್ ಕಸ್ಕೊಂಡಿಲ್ಲ.
application filed with the appellant,
Trial court itself faced out.
saying the execution and operation of the
ಅರೆಸ್ಟ್ ತಗೊಂಡ್ರು.
judgment and decree dated 4/9/2024 passed in OS number 51 of 2022 by the senior civil judge and JMFC Abzalpur. Next para, accepting the reasons stated in the affidavit, plus the grounds made out in the appeal memo, comma. Drawing of the final decree is hereby stayed. Intimate the stay order, the trial court forthwith by mail. Issue notice to all respondents.
Much of.
35 my lords.
45, my lord, item number 45, my lords have heard it. 3.5 years diploma course in nursing.
This is-
It was
Number 35 my lords LIC batch.
only,
Let us see, let us see.
ಅಲ್ಲ
Anyhow,
15th
anyhow, you have a good case before anybody. It's difficult to carry over as part of.
Number 53.
ಅಯ್ಯೋ ಇದೇನ್ ಕೇಳದಿಲ್ಲ ಬಿಡ್ರಿ ಈಗ
Relating to the doctor.
ಮಾಡಕ್ಕೆ ಹೇಳಿ ಬರ್ರಿ ಹಂಗಾರ ಬರ್ರಿ.
Have heard and directed to file this in office and everything.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು, ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
ನಾನು ಕೊಡ್ಬೇಕಾಗ್ಯದ.
ಅವರು
They have intelligently, they have systematically, and my poor lady is under very difficulty to collect all these things. Systematically, they have prepared, and how they manage, I'll demonstrate if time is there, my lord.
It is what the affidavit we have filed, my lord.
No.
Filed before the last year in the domestic violence. I can't go back to that because I have given the.
No, how they have,
Undertake that, because as per the Supreme Court judgment, I have to mention, if it is the statement given by me is false, I have to face the prosecution. That is why I relied on the same affidavit. If they have any.
they have not paid maintenance of, it is 2 lakhs, 7 to 8 lakhs rupees. Because
Oh,
they have
let them-
no, because things are going in a manner, I want my husband, I want to lead my life. I have not taken single money from them, and I have not also sought for maintenance or charges. Under 25 application, it was ready, I have not filed. Because they are very young, the boy is disabled,
They are doctoral.
doctor. ಅದೇನೆಲ್ಲ
Tried our level best, ಏನ್ ಮಾಡಕ್ ಸಾಧ್ಯ? I tried my level best to.
after vacation any day.
My lords kind
Serial
information.
number 48, your lordship.
55 my lords date
48 land acquisition matter, your
and
lordship.
acquisition series matters my lord already informed my clients to withdraw that crop. Well, now they are always they are taking committee. Yes, sir.
The decision to file appeal, that cases also.
Sir.
Sir,
Leave it at that. I'll fix a date.
Yes, my lord. Immediately after occasion, my lord,
List the matter.
35.
Dates you can.
Date ಕೊಡ್ತೀನಿ. Date ಕೊಡ್ತಾರಲ್ಲ.
ಹೋಗ್ಬೇಡ್ರಿ, ಒಂದೇ ಸೆಕೆಂಡ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ ಸರ್. ಸ್ವಲ್ಪ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆ, ಅದನ್ನ ಮೊದಲು ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡು ಮಾತಾಡ್ತೀನಿ.